Do you think you'll be staying any other talk?
Unless I can. It's an expression.
Here, and I'm happy that people are excited about the topic and about the people that we brought here. Great.
Yes, I agree. So. Are you going to set up annotations for this?
Right here, it's that way I can kind of be like an tech manager if someone's having some difficulty. And that's supposed to be a bad hand in case somebody. Yeah.
Turn off.
People seem to be energetic and happy.
I'm going to ask.
Good morning. Good morning. Let's get this program underway. We've got a lot of ground to cover. My name is Sam Jordan. I am a faculty member here at the law school and have been really honored to work with the Law Journal students and the student editors in putting today's program together. My job today is very minimal, which is to be the first of many to welcome you all here and thank you for participating, to those of you who are participating, and thank you for coming and supporting this event, to those of you who are here to observe. I do also just want to make a couple of logistical preparatory remarks. There's been one minor change in the program, which is that Professor Wolf, who is scheduled to appear on the first panel, is unable to join us. And so we're going to make a slight adjustment to the first panel, which we'll cover when we get to it. So just be prepared for that. And then the second is that one of the traditions of Childress is that there are opportunities for questions from our audience members. And so I want to let you know that those opportunities will be coming throughout the day. And so please be prepared if you would like to volunteer. The way that will happen will be that we will have students with microphones who will be walking around. And so if you want to offer a question, or please raise your hand and they will come to you. So with that out of the way, I'm going to turn it over to the Dean of the Law School and then to Ryan Brooks, who is the student editor in charge of the Childress. So thanks again for coming. Dean Johnson.
Thank you, Sam. Good morning. Welcome to St. Louis University School of Law, and welcome to the 2023 Richard J. Childress Memorial Lecture and Symposium. It is so good to see you all here this morning. I'm William Johnson. It is my privilege to serve as dean for this law school community, and it is my honor to welcome you today to this important and exciting Childress Lecture and Symposium, Progressive Constitutionalism and its Libertarian Discontents, the Case of LGBTQ Rights. The Childress Lecture and Symposium is the premier academic event of the year at SLU LAW. It's named for and commemorates a true giant who served as dean for SLU LAW from 1969 to 1976, Dean Richard J. Childress. Richard Childress was a well-known constitutional law scholar. He was a member of the faculty for nearly 30 years, served as associate dean and then dean for a combined 15 years. And his time at SLU LAW was truly transformational. It was transformational in large part because Dean Childress was justice-driven. Among his many accomplishments, he founded the SLU LAW Journal, and he played a significant role in building the nationally recognized SLU Law Library. During his term, interdisciplinary dual degree programs were established with both the School of Medicine and the College of Public Health, and of course, the health law program at SLU LAW today enjoys a reputation as the premier health law program in the country. Childress demonstrated by his actions that he was deeply dedicated to our shared social justice mission as a Jesuit law school in the city of St. Louis. He served on as director of the St. Louis Urban League for more than a decade, and he served on the St. Louis Conference on Religion and Race. Childress was chairman of the Archdiocesan Commission on Human Rights 2 separate times. He participated in the Civil Rights Movement. He joined the March to Selma. His example of justice-driven work and leadership is inspiring for me. I hope it is for you too. And as we see continuing injustice in an unjust world today, including racial injustice, economic injustice, and injustice in the form of anti-queerness that continues to rear its ugly head. His example gives me a sense of purpose. Now, those who know me well have heard me say many times that as a Jesuit law school, we are called to insert ourselves in the world on behalf of the poor, the marginalized, and those who seek justice. That's a calling that we take very seriously as a law school community, and it's a calling that I personally feel in deep and meaningful ways. Our mission has resonance here in this beautiful city of St. Louis with its complicated history, a history that includes, for example, so many examples of Black excellence and joy and community, but also a painful history of enslavement, white supremacy, police brutality, and systemic racism. Our calling has resonance in this region as we see continuing attacks on members of the LGBT community, and in particular attacks on the trans community. That gives our mission particular context here, and continuing violence that is racially motivated and continuing attacks on trans rights and other forms of oppression in this city, in this region, and in this country give our calling and our mission a sense of urgency. It was 25 years ago this month that Matthew Shepard was viciously murdered and a beautiful life was lost. It's true that significant progress has been made, and I am so grateful for that. But there continues to be so much work that remains. And I want to state unequivocally, LGBTQ rights are human rights, trans rights are human rights, and I stand unambiguously and proudly with the LGBTQ community. There is reason to be hopeful. This symposium is a hopeful thing. The work of these brilliant scholars is hopeful. And I am thrilled to announce that a new LGBTQ affinity bar organization is being launched in conjunction with this event. My friend and colleague in the profession, Keith Price, a partner with Sandberg Phoenix here in St. Louis, is relaunching Lawyers for Equality in conjunction with this symposium. Lawyers for Equality will seek to educate the legislature and the community and the profession on the LGBTQ community and LGBTQ rights, and will seek to create a space for belonging and community here in St. Louis. SLU LAW is delighted to support Lawyers for Equality. Keith, I know you're here. Would you wave for me? Thank you so much for your leadership, Keith. The annual Childress Lecture and Symposium offers an important opportunity to come together and wrestle with compelling questions of law and of justice, exchanging ideas, challenging one another, listening carefully to one another, and thinking deeply while we advance our understanding of law and policy and systems and injustice. This symposium, The Case of LGBTQ Rights, offers an especially important and timely opportunity to do just that, as our impressive lineup of experts address an essential subject today. Now, the schedule for the day looks amazing, and there are several people who deserve recognition for that, including all of our SLU Law Journal students. We really have the best students, with all due respect to the visiting professors who are here. SLU Law students are amazing, and our journal students are extraordinary, but I especially want to thank Ryan Brooks, the Childress Symposium editor. Ryan is a terrific student, and he's a wonderful student leader. He had the vision for this symposium. He has worked tirelessly to make it reality. Ryan, you have my deep gratitude. Thank you so much for what you do. And Ryan will be speaking immediately after me. The convener of this symposium is Professor Sam Jordan. Professor Jordan is a talented scholar, a truly gifted teacher, and a wonderful colleague. Sam, once again, you've done amazing work to pull this together. Thank you so much for your leadership. I appreciate it. I've joked with Sam that he does such a good job, he might end up finding himself doing this again next year. We'll see about that. I would also like to acknowledge my staff colleagues, Susie Lee and Julie Orr, who do a lot of the unseen work that makes a symposium like this come together so well. They deserve credit for their tireless efforts. Please join me in thanking Susie and Julie. And finally, without our speakers, there is no Childress Lecture, there is no symposium. And the lineup of speakers today is fantastic. My thanks to each of you for your time, your insights, and your contributions to the conversation. I'm especially grateful to our keynote speaker, Professor Carlos Bull. Professor, thank you for being here. Thank you for your work. It's work that matters a great deal. I look forward to your address. I look forward to the day. Thank you, everyone, for being here. Welcome to SLU Law. Please join me in welcoming Ryan to the stage.
Good morning, everybody. As you may have heard, my name is Ryan Brooks, and I'm the Childress Managing Editor for this year's Childress Lecture. I really just wanted to start by thanking y'all for coming, but also for being in community. That the main thing I wanted to touch on just before introducing our keynote speaker is the fact that this community is the St. Louis community that has been around us the entire time. Although we're brought together in this room right now for the purpose of LGBTQ plus rights, understanding them, and learning about how to better advocate for them as progressives. This discussion, this panel, the ideas that we talk about here are not confined to this room. And in fact, I hope that everybody takes away what we talk about here and puts it into practice in the real world. A big emphasis of this event for me stemmed from an event we had in 1L year in this same room where there was only about 4 people in Outlaws. We were all together, and the event put in a way, it made the representation that LGBTQ plus rights were up for debate. That the notion of equal protection for all humans, regardless of their identity or their orientation, it was surprising to me when I came here that would occur. But it was also the start of something where over the course of these past few years, we have built out a robust and accepting community that, although existed before and to a fair degree, has only grown stronger over the obstacles of things like COVID, but also the startling national trends that weigh on the minds of so many students, so many faculty, so many people working in the administrative arms, and so many people working in the service portions of the school. So with that, I'd just like to make sure that everybody, as we get into the panels today, continues to think of the people around them, continues to hold in mind that the ideas here should not just be confined to this room, but should be carried with us out into our community. And I think that our panelists that we've assembled today are very aptly capable of doing that. Moving to Professor Ball, I just first wanted to thank you for taking the time to come, but also to contribute your ideas and address an audience here where oftentimes the outlook is bleak, and people in other areas do generally sometimes take the perspective that rights are up for debate. But this event is not about debating whether rights exist. It's about debating how the rights should exist, discussing how we can be best an advocate. And that's something that Professor Ball has a motif through his work, stemming back to the beginning of your publication, where you have written books on the First Amendment, written books on how queerness influences corporate America. In your teaching, you have inspired and you have been able to spread knowledge in a way that is inclusive and that advances LGBTQ rights. And it's an honor to have you here. And as you can see as mentioned at the reception yesterday, that so many people were willing to come at the recommendation, at hearing that you were going to be here. And so it's truly an honor for me to introduce Professor Carlos Ball to talk to you all today. But thank you.
Thank you so much. Good morning. What an honor it is to kick off this wonderful program. And you know, one of the I don't know if it's an upside or a downside of reaching more towards the end of my professional career as opposed to the beginning, just because of age. I can kind of look back on that career, and I have more behind me than I have in front of me. So I think I can say with full confidence that this invitation and being here today is one of the highlights of my professional career. So thank you to Ryan. A special thank you to Ryan, and a special thank you to Sam Jordan, who did a wonderful job last night, by the way, at the symposium, at the dinner prior to today's symposium. He thanked everybody, but nobody thanked him. I'm so glad the dean thanked him this morning. Sam, it's been a pleasure to work with you and with you, Ryan, in putting this program together. I think you're both emblematic of this institution, and I congratulate you as an institution for having the quality of human beings such as Professor Jordan and Ryan Brooks. I want to use my time with you this morning to explore the ways in which libertarian political morality and constitutionalism constitute a double-edged sword for progressives. On the one hand, libertarian principles have helped advance progressive objectives inside and outside of the courts, including those related to LGBTQ rights. On the other hand, abiding by libertarian principles as a matter of constitutional law has served to jeopardize a slew of broader progressive, distributive, and egalitarian objectives. And with those broader goals in mind, I will argue this morning that it is important going forward for progressive proponents of LGBTQ rights to articulate and defend moral and constitutional frameworks that challenge rather than strengthen the libertarian ethos. An ethos that I will argue and try to persuade you of has in recent decades served as powerful impediments to the attainment of many progressive policy goals. I think that in many ways, conservatives in recent decades have defended principles of political morality and constitutionalism that, regardless of their substantive merits, have been more internally consistent and coherent than those articulated by progressives. Right-wing policy and legal positions in the United States are generally constructed around a libertarian ethos that repeatedly challenges the purposes, effectiveness, and constitutionality of governmental, economic, environmental, health, and safety regulations and policies. The libertarian ethos is deeply skeptical of government, almost never viewing it as a source of solutions to economic and social problems, while almost always blaming government for causing or exacerbating those problems. From a libertarian perspective, the key to promoting both human flourishing and societal good is to protect negative rights to liberty. Rights aimed at letting individuals pursue their interests, including economic ones, as they deem best, free from governmental intervention or interference. Conservative political movements in recent decades have generally embraced the libertarian ethos as a way of defending existing allocations of wealth, income, and property that are presumed to be fair and just because they are determined by the choices of individuals purportedly acting freely through market transactions. The political and constitutional frameworks articulated and defended by American progressives in recent decades have been more muddled. Part of a progressive vision of a fair and just society is grounded in a distributive ethos that demands significant governmental involvement in redistributing resources and promoting human flourishing and reducing inequality. For progressives, current allocations of economic power and benefits are suspect given the long histories of discrimination and exclusion and subordination of people of color, of poor people, of women, of disabled people, of LGBTQ individuals, among others. Principles of distributive justice call for a government that is willing and able to reallocate wealth and income as distributed by the economic marketplace. And while the libertarian ethos calls for the protection of negative liberty rights only, rights of non-interference, a progressive ethos embraces a positive understanding of liberty that calls on the government to act affirmatively to create the necessary social and economic conditions that make the exercise of meaningful liberty and equality possible. Now, in this brief summary, as I have presented it so far, there are clear and irreconcilable differences between the libertarian ethos and a progressive distributive one. The issue that I want to talk with you about this morning is how the introduction of matters related to sex, sexuality, and gender identity into politics and law has brought crucial aspects of the libertarian ethos into progressive thinking and advocacy. This gives rise to a problematic inconsistency that is internal to progressive political morality and constitutionalism. In seeking to promote and protect the personal, sexual, intimate, reproductive, and gender identity freedoms of all persons, especially women, LGBTQ people, and gender nonconforming individuals, progressive theory in matters of personal autonomy has tended to embrace three crucial aspects of the libertarian ethos. The first is an atomistic understanding of the self. That is, one that views individuals as largely disconnected and independent from others. The second is a deep skepticism of governmental interventions, a skepticism grounded in the notion that the state on matters of personal autonomy is almost always the source of the problems and almost never the font of their solutions. The third feature is a negative conception of liberty that in emphasizing rights to privacy and to be left alone exclusively imposes on the government duties of non-intervention without also requiring it to act affirmatively in order to protect and promote liberty and equality. It seems to me that if progressives want to successfully harness the power of the state to redistribute resources in ways that make our society more fair and egalitarian, as a means of permitting everyone, regardless of class, race, ethnicity, gender, sexual orientation, or disability, to flourish, we need to purposefully and systematically explore how to make sure that in pursuing certain political or legal objectives, we do not unintentionally strengthen the libertarian ethos that so powerfully stands in the way of the attainment of distributive and egalitarian progressive objectives. So I want to do three things with the rest of my time. First, I want to explore the influential role that the libertarian ethos has played since the 1950s, both in the push by progressives for the recognition of the constitutional rights of LGBTQ people, and in the Supreme Court's understanding of substantive due process doctrine, including in Justice Kennedy's crucial opinion in Lawrence versus Texas, in which the Supreme Court struck down as unconstitutional sodomy statutes. Second, I want to examine other parts of Justice Kennedy's constitutional jurisprudence to show how the same libertarian principles that have advanced LGBTQ rights positions in the courts have also served to judicially block the attainment of many other progressive objectives. So I'm going to do something that is not usually done in a talk about LGBTQ rights. I'm also briefly going to talk about, for example, affirmative action, Obamacare, and campaign finance reform. I'll finish by offering some thoughts on how progressives going forward can articulate and defend pro-LGBTQ rights positions in ways that challenge rather than strengthen the libertarian ethos. It is in many ways hardly surprising that the early gay rights movement of the 1950s and 60s prioritized the shielding of sexual minorities from the state's coercive powers. At a time, for example, when state and local officials arrested tens of thousands of LGBTQ people between 1946 and 1961 for engaging in consensual sexual intimacy, as well as for dancing, kissing, and engaging in other open displays of affection, the focus of early activists by necessity had to be on protecting sexual minorities from the outright harassment and coercion by state actors. Early LGBTQ rights activists believed that the best way of accomplishing this objective was through the recognition of rights to non-interference that would protect gender and sexual minorities from some of the worst manifestations of state repression. At a time when same-sex sexuality was subject to vicious and relentless social, moral, and legal disapprobation, the notion of restricting the state's authority to criminalize private and consensual sexual conduct that did not tangibly affect others, much less harm them, was obviously appealing to those who had progressive views on human sexuality. As a result, the libertarian philosopher John Stuart Mill's harm principle seemed particularly well suited to the push to decriminalize same-sex sexuality while limiting the coercive powers of the state as deployed against LGBTQ people. And we see this type of reasoning behind the recommendations in the 1950s by the Wolfenden Committee in the United Kingdom and by the American Law Institute in the United States to decriminalize consensual sodomy. A few years later, of course, the Supreme Court in Griswold versus Connecticut first recognized the constitutional right to privacy by protecting the ability of married couples to use contraceptives. The court a few years later expanded the right to include unmarried couples in a case called Eisenstadt versus Baird. And in Roe versus Wade, as we all know, the court explicitly relied on the right to privacy under the Due Process Clause to protect the right of pregnant women to choose to have an abortion pre-viability abortions. But at the same time that the court was recognizing the negative rights of individuals not to be interfered with by the state and making important personal decisions impacting their intimate lives and reproductive capabilities, the court also consistently rejected the notion that the Constitution imposed affirmative obligations on the government to advance the liberty and equality interests of individuals. For example, the court in a case called San Antonio Independent School District versus Rodriguez decided the very same year as Roe versus Wade, the court in that case held that the Constitution does not afford children an affirmative fundamental right to an adequate education. About a half a century earlier, the court in a case called Pierce versus Society of Sisters had held that the government, under the doctrine of substantive due process, could not prevent parents from sending their children to private schools if they could afford it. But the court in Rodriguez refused to hold that the state has a constitutional obligation to provide education to children, right? So in other words, according to the court, the Constitution protects parents as consumers of educational services to use private funds, if they have them, to pay for the education that they believe is best for their children. But parents, as members of society, do not have a constitutional right to state-provided education for their children. The due process clause, as interpreted by the court, protects the negative right of parents to be free from state interference in their use of private resources to participate in and benefit from the educational marketplace in order to pursue their preferred educational objectives. But the clause does not offer parents an affirmative right to have the government provide even the basic and essential public good of public education for their children. The court also abided by the libertarian ethos in Rodriguez when it further concluded in that case that wealth is not a suspect classification under the Equal Protection Clause. This means that the government, in setting policy, is free to take existing allocations of wealth and income, no matter how unequal, as it finds them, without any affirmative constitutional obligation to render the allocations more equal or to try to mitigate their effects on the ability of poor individuals to participate in or contribute to society. Juxtaposing Roe versus Wade with the abortion funding cases that followed shortly thereafter also illustrates the ways in which the court's understanding of liberty under the Due Process Clause has tracked the libertarian ethos. The court in the abortion funding cases from the 1970s made clear that the constitutional right to an abortion, as it existed then, it no longer exists today, was limited to the negative right of pregnant women not to have the state interfere with the decision of whether to carry a pre-viability fetus to term. But there was a crucial constitutional distinction. The court reasoned only 4 years after Roe versus Wade between not being able to get an abortion because of state restrictions on the procedure, right? That might be unconstitutional, and not being able to get an abortion because of the state's refusal to fund them for those who could not afford them. That was not unconstitutional. As in Rodriguez, the critical constitutional baseline, as far as the court was concerned, was the distribution of economic resources as they already existed. It was in this libertarian constitutional environment that the challenge to Georgia's sodomy statute in Bowers versus Hardwick arose in 1986. Not surprisingly, therefore, the challenge was grounded in the type of negative liberty claim that the court was most likely to accept. That is, that the Constitution protects the rights of individuals to be free from governmental interference in important personal matters. In this case, the choice to engage in sexual intimacy with another adult in the privacy of, with another adult of the same gender in the privacy of the home. And the Supreme Court brief filed by Professor Lawrence Tribe on behalf of the gay challenger in Bowers asked the court to rule in a way that constitutionally codified Mill's harm principle. As the brief explained, while the state had considerable constitutional authority to regulate sex outside of the home due to the government's, quote, fundamental duty to shield us from harms wrought by others, unquote, such a concern was wholly absent in the case of consensual adult sexual conduct in the bedroom. From a progressive perspective, I think there are at least 3 interrelated limitations that adhere in the type of constitutional privacy claim raised in a case like Bowers. First, the claim fails to provide or promote a conception of the self that is defined in ways that go beyond self-sufficiency and independence from others. The privacy claim presents an understanding of the self that, aside from the pursuit of sexual intimacy, is not otherwise embedded in or dependent on ongoing relationships or communities. And if you will excuse me for one moment, I need to blow my nose. I apologize. Instead, the privacy claim, like libertarian theory more generally, offers a conception of the self as an atomistic creature who is entitled to protection from state coercion, but otherwise has no particular needs to be nurtured, encouraged, or supported by others. Although progressive understandings of the self can vary in emphases and dimensions, they generally prioritize the self's relationships with and interdependencies on others, factors that are entirely missing from or irrelevant to a libertarian and atomistic conception of personhood. The privacy claim's first limitation fosters a second one, an understanding of liberty that is confined to its negative components. That is, to the notion that the only obstacles to freedom that matter morally and constitutionally are restrictions and constraints imposed by the government on independent and self-sufficient individuals. This understanding of liberty is inconsistent with the progressive view that social and economic conditions can undermine individual freedom as much as coercive regulations, if not more. From a progressive perspective, liberty depends upon the existence of social and economic conditions that facilitate the individual's capacity for meaningful choices and opportunities. Third, and relatedly, an exclusive focus on negative rights to liberty exercised by atomistic individuals fails to ask a crucial question for the attainment of progressive, distributive, and egalitarian objectives. Namely, what are the government's moral and constitutional obligations to act? If the Bowers Court had accepted rather than rejected the privacy claim, the government would have been constitutionally required to cease regulating or interfering with the intimate sexual conduct in question. But when we broaden the lens to focus on progressive objectives related to distributive and egalitarian justice, the staying of the government's regulatory hand, whether constitutionally mandated or prudentially chosen, impedes rather than advances the attainment of progressive objectives. Among other things, when the government fails to act, it leaves in place existing market-based allocations of wealth and income. While this is the outcome that the libertarian ethos requires, it is the precise opposite of what the progressive ethos demands. The libertarian ethos was also reflected in the court's overruling of Bauer 17 years later in Lawrence versus Texas. Now, it is undoubtedly true that Justice Kennedy's opinion in Lawrence, by recognizing that individuals, adults, have a constitutional right to engage in consensual same-sex sexual conduct in private, was a historical milestone that benefited LGBTQ people in many ways. I'm not denying that. Nonetheless, we need to keep in mind that Justice Kennedy in Lawrence forcefully and strictly abided by the libertarian ethos. For example, he generally offered an atomistic understanding of the self, one that views individuals as fully capable of exercising liberty by making isolated and insulated choices free of connections to or dependencies on others. Lawrence also understood liberty entirely as a negative right to be protected from government interference. From this perspective, state action is understood only as a threat to liberty, never as a precursor or originator of it. Protecting liberty from this vantage point requires the regulatory diminishment of the state. In short, the ruling's normative focus was an individual choice exercised entirely free from governmental involvement. Not surprisingly, therefore, Lawrence did not even consider the possibility that the government might have constitutional obligations to act, as opposed to refrain from acting in order to promote human liberty. In thinking about Lawrence, we need to remember that while issues related to LGBTQ sexual freedom are an important part of the progressive agenda on matters related to sex and sexuality, that agenda is far broader. For example, protecting victims of sexual crimes and domestic violence has also been, through the decades, a crucial progressive objective. And such protection is impossible, as progressives have argued, without significant governmental intervention, not only in terms of doing the basic and enforcing the criminal laws against abusers, but also in terms of supporting and funding the needs of the victims of sexual and domestic violence. The protection of the liberty rights of those victims, that is, their rights to be free from intimidation and physical and psychological abuse, requires significant governmental involvement rather than the staying of the state's regulatory powers. It is that kind of reasoning that finds no support in Lawrence. But what about Obergefell versus Hodges, right? Did Justice Kennedy, in his same-sex marriage opinion from 2015, did he evince a different and more capacious understanding of liberty in that ruling? Well, on the one hand, Kennedy and Obergefell made clear that the understanding of liberty set forth in Lawrence was not enough to fully protect the liberty rights of lesbians, gay men, and bisexuals, right? As he put it in a famous sentence, quote, outlaw to outcast may be a step forward, but it does not achieve the full promise of liberty. Such a promise, Justice Kennedy now concluded, required the government to offer same-sex couples the opportunity to marry. It can be argued that Obergefell at least implicitly recognized a link between the ability of individuals to exercise their liberty rights and positive governmental action, given that the constitutional violation in that case, unlike in Lawrence, was remedied through governmental regulation rather than through its absence. The constitutional problem in Obergefell was not that the state was regulating too much, as was the case in Lawrence. Instead, the problem with same-sex marriage bans, from a liberty perspective, I would argue, was that the government was not regulating enough. When it came to same-sex marriage, it was the government's decision to stay its regulatory hand that led to the liberty violation. But Justice Kennedy's understanding of the link between governmental action and human liberty in Obergefell was not grounded in a normative or constitutional commitment to the idea that protecting liberty sometimes requires the government to deploy, rather than stay, its regulatory authority in order to create the social and economic conditions that make the exercise of autonomous decisions possible. Instead, for Justice Kennedy, the obligation on the state to act affirmatively by recognizing the relationships of same-sex couples as marital was the result of the, for him, unique value of the institution of marriage. Nothing in the opinion suggests that he believed that government involvement could play a positive role in promoting human liberty outside of the, again, for him, distinctive and special context of marriage. But it wasn't only Justice Kennedy who failed to broaden the analytical lens to consider the possibility that sometimes government involvement might expand rather than restrict the ability of individuals to make meaningful choices on matters related to personal relationships and sexuality. For the most part, marriage equality proponents, I think, also failed to broaden the analytical lens beyond the libertarian ethos. As both a conceptual and normative matter, the question of marriage equality was not about the right to privacy and the right to be left alone. Same-sex couples who wanted to marry before Obergefell were not asking for the government to get out of their lives. Instead, they were demanding governmental regulation as a means to attaining meaningful liberty and equality. The government's failure to intervene by regulating their relationships as marital, or at least giving them the opportunity to choose to be regulated, undermined rather than promoted the liberty and equality interests of same-sex couples. Theoreticians of marriage equality, therefore, could have emphasized how the exercise of liberty and the attainment of equality often depend on the government taking affirmative steps to create the social and economic conditions that provide individuals with meaningful choices and opportunities. In making the point that liberty entails more than the negative right to be left alone, constitutional theorists and others who supported marriage equality could have challenged the libertarian ethos by noting that if the government has a constitutional obligation to create a legal framework that provides same-sex couples with the opportunity to marry, then it might also have constitutional duties to act affirmatively in other crucial areas of government policy, including education, housing, and healthcare, that impact the ability of individuals to make meaningful choices about how to lead their lives. Unfortunately, marriage equality proponents generally failed to make that connection. The negative right to liberty might protect what takes place in the bedroom, but bedroom activity, so to speak, is only one facet of what it means to construct relationships, families, and communities around a same-sex sexuality. Indeed, it is entirely possible to fully protect the right to privacy in the bedroom while leaving firmly in place the repressive consequences for LGBTQ people of being forced to lead closeted lives. A fuller and richer understanding of liberty than that offered by the libertarian ethos can account not only for the freedom that individuals enjoy when they close the door of their homes behind them, but also for the range of options and opportunities available to them when they open those doors and come out to participate in the social and communal world around them as open LGBTQ people. In many ways, the push for marriage equality was a community-wide coming out of the closet for sexual minorities in this country. I suspect that one of the reasons why marriage equality proponents did not emphasize the affirmative or positive role that state can play in promoting LGBTQ liberty and equality is that historically government actors in the US have been intimately involved in the repression of sexual and gender minorities. But I suspect that another reason for that failure is the hegemony and influence of the libertarian ethos, which in framing so much of our moral, political, and constitutional discussions in this country discourages explorations of affirmative government obligations and positive understandings of liberty. I think that in the end, the push for marriage equality was a missed opportunity to frame LGBTQ rights positions in ways that challenge rather than strengthen the libertarian ethos, and in the process could have helped promote rather than undermine the attainment of other important progressive objectives. I want to shift now and focus more explicitly on Justice Kennedy's libertarian constitutional jurisprudence beyond LGBTQ issues. When we widen the lens to assess the impact of other parts of Kennedy's constitutionalism on broader progressive objectives, I think it helps illustrate how promoting and strengthening the libertarian ethos to attain some progressive objectives can undermine the attainment of many other progressive goals. Justice Kennedy's abiding skepticism of government worked well for progressives on LGBTQ issues, but not so well in many other policy areas of great interest to progressive movements. One of those policy areas was affirmative action. As we know, progressives generally defend affirmative action programs as efforts to create economic and social opportunities for groups subjected to past discrimination and exclusion. From this perspective, meaningful liberty and equality for traditionally subordinated groups is not possible in the absence of affirmative governmental action. But the libertarian Justice Kennedy was highly skeptical of the constitutionality of government affirmative action and policies and their distributive and egalitarian objectives. In repeatedly voting to strike down affirmative action policies, Kennedy gave no constitutional weight to the ways in which those policies sought to help members of traditionally disadvantaged groups gain access to the economic, social, and political opportunities denied to them by past discriminatory policies. For Kennedy, there was no constitutional distinction to be made between the racially invidious policies of the past and more recent measures intended to address and rectify the unequal opportunities engendered by those very same policies. While many progressive supporters of LGBTQ rights in Lawrence embrace Kennedy's conception of the atomistic individual who only needed to be left alone by the state to attain liberty, few on the left seem to realize that he used the same understanding of the self to question the constitutionality of affirmative action programs. As he put it in one of his affirmative action opinions, quote, under the Constitution, the individual, child or adult, can find his own identity, can define her own persona without state intervention that classifies on the basis of his race or the color of her skin. This reasoning, except for the racial part, is exactly the same one that he had used several years earlier in Lawrence. From Justice Kennedy's perspective, there seems to have been little constitutional difference between sodomy laws and affirmative action programs, right? From his libertarian vantage point, they both involve problematic state interventions that interfere with personal autonomy and choices. For him, the solution in both settings was to get the government out of the way by forcing it under constitutional mandate to stop regulating. Justice Kennedy took a similar libertarian and anti-distributive position in Sebelius, the Obamacare case from 2012. In that case, Kennedy joined 3 other justices in using federalism principles to urge for the striking down of Obamacare in its entirety, including the dozens of provisions that had nothing to do with the 2 measures that were actually challenged in that case. For Kennedy, federalism was a means to promote the end of human liberty. As he put it in one of his rulings, quote, by denying any one government complete jurisdiction over all the concerns of public life, federalism protects the liberty of the individual from arbitrary power. Now, it is worth pausing a moment to note that the repeated reliance on federalism principles by those promoting racist policies throughout our nation's history powerfully challenges the notion that there is somehow an intrinsic relationship between limiting federal authority, the cause, and protecting liberty, the end. In fact, meaningful protections for the equality and liberty rights of Black Americans, including those related to their ability to exercise the fundamental right to vote, to seek employment without being discriminated on the basis of race, to purchase goods and services from public accommodations, were not put in place until the federal government acted affirmatively through legislation, most prominently the Civil Rights Act of 1964 and the Voting Rights Act of 1965, over the fierce opposition of states' rights opponents. But the relationship between affirmative government action and protecting liberty and equality was utterly invisible to the libertarian Justice Kennedy. In fact, his understanding of the link between federalism and liberty, which in fairness he shared with several other justices, illustrates the extent to which promoting liberty from his perspective entailed only protecting individual autonomy from governmental intrusion. To bring it back to Obamacare, for libertarians, the Affordable Care Act infringes on the freedom of individuals to decide how and when to become market participants. A distributive and egalitarian justice perspective, of course, offers a radically different understanding of the link between Obamacare and liberty than that offered by the libertarian ethos. The progressive perspective focuses on the benefits of government intervention in the healthcare marketplace for individuals who would otherwise lack access to healthcare. Without such access, life choices are significantly impaired and limited. Universal access to adequate healthcare helps everyone, and not just those who can afford it, manage the limitations and frailties of the human body. From this progressive perspective, Obamacare does much more to enhance personal liberty than to restrict it. It's worth noting that Kennedy also joined court majorities in using federalism and its purported liberty-enhancing objectives to render Section 5 of the Voting Rights Act unenforceable, to strike down 2 federal gun control measures, and to strike down the civil remedies provision of the Federal Violence Against Women Act, among many other laws. In all these cases, Kennedy used his understanding of negative liberty as refracted through federalism principles as a means to block the federal government from using its regulatory authority to attain generally progressive objectives. Now, let me briefly shift to the First Amendment, which is going to be the subject of considerable discussion among some of our panelists today. There have been extensive recent explorations in the law reviews of the ways in which the Roberts Court has repeatedly used the First Amendment to advance deregulatory objectives that, as during the Lochner era of the early 20th century, challenge a wide array of government regulations. Arguably, the most prominent example of this phenomenon is Justice Kennedy's infamous opinion in Citizens United. Now, much has been said about that case. I only want to make 2 brief points about it. First, Kennedy and Citizens United rejected the notion that Congress has the constitutional authority to restrict the ways in which the accumulation of wealth through market transactions in the economic sphere spill onto the political sphere. While Congress viewed the unrestricted use of private wealth as a distorting and potentially corrupting influence on elections and ultimately on government policies, for Kennedy, the influence that money buys for wealthy corporations and individuals in the political sphere is simply the way in which capitalist democracies are supposed to work. Second, Kennedy's ruling in Citizens United also reflects an exclusively negative understanding of liberty rights. Citizens United viewed the campaign reform provision at issue in that case only from the perspective of its potential threat to corporate speech. But it was also possible to view that very same provision from a positive liberty perspective that recognized the state action under challenge as an affirmative step to expand opportunities for speech for those who lack access to the millions of dollars that our capitalist society permits wealthy corporations and individuals to accumulate, and who therefore cannot use massive amounts of money to amplify their speech. From this perspective, the regulation promoted more rather than less speech by reducing the risk that the money-propelled voices of some participants in politics and elections would drown out the voices of those with far fewer financial resources. My central point is that the same libertarian constitutionalism embraced by the justice, whose opinions have undoubtedly been the most supportive of LGBTQ rights in the history of the Supreme Court, also served to block the implementation of many crucial laws and policies supported by progressives. I believe, therefore, that progressive proponents of LGBTQ rights going forwards need to articulate and defend moral and constitutional frameworks that challenge rather than strengthen the libertarian ethos. I'm going to offer some suggestions about how to go about doing that at the very end of my talk. But before I do, I want to spend a couple of minutes talking about questions of judicial review and their place in the pursuit of LGBTQ rights. The libertarian ethos relies on a simultaneously robust and benign understanding of judicial power. Libertarians believe that judges have a crucial and positive role to play in issuing judicial constitutional vetoes to block redistributive and egalitarian laws. In sharp contrast, some progressive theorists in recent years have criticized a juridically centered constitutionalism, viewing it as at best a distraction from and at worst an impediment to the attainment of progressive objectives. These constitutional theorists have emphasized the need to focus on legislatures and on voters as opposed to so heavily on the courts. And the questions that interest me in this lecture, namely why and how LGBTQ rights supporters should challenge rather than strengthen the libertarian ethos, there is an entirely pragmatic reason for supporting the view that progressives should focus their energies and attention on the political and legislative spheres rather than on the judicial one, right? The Supreme Court is currently constituted and for the foreseeable future is highly unlikely to be receptive to moral policy and constitutional arguments and claims that question and challenge the libertarian ethos. At the same time, the current reality for LGBT communities on the ground is that they will need to seek federal judicial protection as long as legislatures and conservative states continue to enact harmful and discriminatory anti-LGBTQ laws. This, I believe, places progressives in a dilemma with no easy solutions. On the one hand, as I have argued, working within the libertarian ethos to which the courts are likely to be predisposed has real negative consequences. On the other hand, in our current repressive times, I don't believe we can dispense with judicial strategies altogether. As a result, it will not be possible or desirable for LGBTQ rights supporters, at least in the judicial sphere, to completely give up on libertarian arguments. Nonetheless, it is important, I think, for progressive activists, commentators, and academics to consider how specific constitutional claims made in court impact the framing of policy questions outside of the judicial context. This is particularly vital given the ways in which constitutional arguments in the United States often set the boundaries of broader moral and political discourses. Now, I concede that framing LGBTQ rights issues around the government's affirmative moral and constitutional obligations may seem like a luxury at a time when LGBTQ people in general and transgender individuals in particular are the target of well-organized and virulent political and legal campaigns to restrict their rights. In this coercive and frightening political environment in which we currently live, including right here in Missouri, it is tempting to articulate, defend, and promote the interests of LGBT communities in the traditional libertarian way. But for the reasons I have outlined, I believe we should resist that temptation. So to give you a couple of examples, a traditional libertarian way of responding, for example, to the growing number of laws banning gender-affirming healthcare for minors would be to criticize them in part for violating the liberty rights of parents to make important decisions about their children's well-being. And indeed, the recognition and enforcement of a negative right to parental autonomy, as applied to issues of transgender healthcare for minors, allows parents who have access to financial resources and access to healthcare to decide to purchase the medical services that they believe are best for their children. But the negative right by itself does not permit parents of transgender minors who lack the requisite financial resources to make decisions about what is best for their children's welfare. Even in states that have not enacted transgender medical bans for minors, parents who lack adequate access to healthcare services are not able to choose gender-affirming healthcare for their children, even if they believe that such care is essential for their well-being. When morally and constitutionally assessing how the government treats transgender individuals, we should not only focus, as the libertarian ethos encourages us to do, on whether the government has enacted coercive regulations, such as laws banning gender-affirming healthcare. We should also focus on what the government refuses to do, such as guaranteeing access to adequate healthcare, including transgender healthcare to all individuals who cannot afford it. An exclusive emphasis on negative rights and on the government as an impediment to liberty and equality, rather than as an aid in the provision of both, serves to engender a skepticism of the state qua state. And such a skepticism inevitably works to the detriment of progressive objectives. The libertarian ethos of negative rights and limited government also has little to offer LGBTQ individuals in matters related to education, which, like healthcare issues, have recently been the subject of much contestation and complaining by opponents of LGBTQ rights. The simple fact that public school systems educate a majority of children in the US means that the libertarian mantra of, get the government off our backs and we will be free is wholly inadequate to help LGBTQ students in public schools. Such assistance can only result from affirmative and inclusionary public education policies that purposefully seek to avoid making LGBTQ students choose between receiving an adequate education on the one hand and living openly according to their gender and sexual identities on the other. To be free to live and love in the closet is no freedom at all. What progressivism fundamentally asks of government on behalf of LGBTQ people is not that it leave us alone by getting out of our lives, but is instead that it help create the necessary conditions, including but not limited to in the spheres of healthcare and education, that make it possible for us to lead free, full, and equal lives without having to hide or compromise our sexual and gender identities. A progressive push for LGBTQ rights should aim to persuade Americans that the menu of moral, policy, and constitutional choices is not limited to those offered by a repressive, transphobic, and homophobic state on the one hand, and those provided by a libertarian state that does little more than leave LGBTQ people alone on the other. While from a progressive perspective, a libertarian understanding of state authority is obviously much better than a repressive one, there is a third alternative that is more consistent with broader progressive values and objectives. An understanding of state authority that is defined in crucial ways by positive moral and constitutional obligations on the government to create social and economic conditions that promote the full flourishing of all of society's members. By emphasizing the extent to which meaningful liberty and equality depends on state action, LGBTQ rights supporters can help reduce the skepticism of government that libertarians have been so effective in promoting and spreading since the 1980s. Unless those of us who consider ourselves to be progressives on LGBTQ issues and many others challenge the notion that the government is the problem and not the solution with the same vehemency and consistency that libertarians defend it, we will have little chance of truly transforming the American society by making it a more just and equal one. I fully recognize that persuading Americans, to say nothing of federal judges, that the government has affirmative moral and constitutional obligations to promote human flourishing and advance liberty and equality for all is a process that will require Americans to put considerable faith in government intervention and regulation, a process that will not be easy. Accomplishing this feat will require multi-pronged approaches and strategies and will likely be a multi-decade effort. But unless progressives consistently and unabashedly highlight the benefits of active governmental involvement to attain distributive and egalitarian objectives, the libertarian ethos will remain unchallenged and firmly in place. It will not be easy to effectively promote LGBTQ rights without strengthening the libertarian ethos, but I believe that for progressives, it is essential that we try. Thank you very much.
So now we'll be taking a brief break. Oh, yeah, we'll do sorry about that, the Q&A next, and then the break. They're in this.
Okay, this works. Anybody want to use it?
Thank you so much. I think your point of this affirmative duty of the government is an important issue and idea. My experience with law school over the years and lawyers is that generally, of course, a good percentage of them are committed primarily to protect the power and wealth of the status quo. That's in fact their career objective. So my first question would be, what would be a key case for this new point of view that you might see us working toward to establish this principle on a stronger basis? And the second point is, do you suggest, or is there a collective that might take its goal of developing a strategy, like you say? For example, the Federalist Society is very strong in what it does. Might there be a counterpoint? Maybe there already is, but I'd just like to hear your comment.
Yeah, I'm not sure. I'm not, yeah, well, I guess I should use this microphone. So yeah, on your second question first, yeah, I'm not sure that there is an equivalent to the Federalist Society. And I think having one the American Constitution Society is an alternative to the Federalist Society, but I'm not sure it's had quite the same impact, especially when it comes to placing judges in the federal judiciary. And so I do think we need advocacy groups to be thinking about, kind of tying some of this together. I think what we have now in progressive politics in the United States is more of a sort of silos, right? We have folks working on healthcare issues and on housing issues and on discrimination, civil rights issues, right? And I think the conservative movement in general, and I was focusing more in my remarks on sort of the theoretical part of this, but on the political pragmatic side of this, I think the right has done a better job in its political advocacy in having consistent themes and principles. And for whatever reason, the left doesn't seem to be quite so good at that. And I'm not sure that's really only an American phenomenon. I think that happens in other countries as well. So I don't have particularly, so I think this is an area that people who know much more about this might be to think about how to create such inter-group communication among progressive movements. On your first question about the law and law students and the way in which the law is used to protect the status quo, I mean, I don't put that so much on law students as the nature of the law, right? The nature of the law itself is a conservative institution that is, broadly speaking, focused on protecting the status quo. And I think that's, as we are now experiencing almost, on a monthly basis from Supreme Court opinions, there are real limitations, right, to what progressives can achieve by making legal constitutional arguments in the courts. And so I think what needs to happen ultimately is to go back to the framework of the 50s and 60s and 70s, where more progressives were focused on legislatures as opposed to on courts. And that, by the way, is intimately related to the way in which we teach the law, right? Because the way in which we teach the law is very juridically centered, right? It's almost exclusively, certainly when it comes to constitutional law, about what the courts have said and what the courts haven't said, right? With very little attention to other institutional players. So thank you for your questions.
Professor Ball, I enjoyed your talk.
Thank you.
As I was listening, an elephant entered the room.
Okay.
In 1963, Phyllis Schlafly wrote a book called A Choice, Not an Echo. She challenged the Rockefeller Republicans, the libertarian wing of the party, called them not true conservatives. She said Republicans needed to reorient themselves around social conservatism.
Mhm.
And then she launched a massive campaign to stop ERA, fight Roe, and the subsequent 50 years of conservative politics have ironically been anti-libertarian, including our new Speaker of the House, Mike Johnson, who said same-sex marriage is the harbinger of chaos and sexual anarchy. So how do you deal with the idea that conservatives are doing exactly what you are saying we should do? They're dismantling the libertarian ethos, and the elephant is sitting right behind you.
Well, yeah, it is a big elephant. But the new speaker also said that he wants to drastically cut back, right, on the regulatory powers of the federal government, right? And when you look at that other side of the conservative political agenda, I would argue is very much tied to this notion of the government as the source of many threats to liberty. Now, what you're saying, Anders, and I completely agree that there is an internal inconsistency there as well, right? Because there's absolutely considerable tension between libertarian theory and social conservative social policies. But somehow that coalition, which really started to form in the 1980s, right? That's one of the things that accounted for Reagan's rise to power, right? He was able to please the libertarians at the same time that he was able to please the social conservatives. At the end of the Obama administration, I was hoping that that coalition would start to fray, and that progressives would be able to take advantage of that fraying. I understand the tension that you're referring to from an analytical perspective, but I'm not sure that that tension is limiting in any significant way the ability of corporate America, the ability of the Koch brothers, the ability of the Cato Institute, et cetera, to work with the social conservatives to attain libertarian ends.
Okay, we are up against our first break, and I don't want us to get too far behind schedule. So we will reconvene in just a few minutes for our first panel discussion.
Thank you.
That was really good.
Yeah, thank you so much. You're really kind. And so good to meet you.
Good stand, but I think you should be able to see the power of the computer. Yeah, and then I can give you. Probably be best if you could, yeah, and I can give you the keyboard and
But make sure. Tell me, SLU, do they have town hall the first year?
yes, you do have
So
some.
the first one, right? I'll tell you what it is. So not everyone.
Yeah,
I
not that,
haven't taken time. I'm like, it's fine.
it's not required, it's highly recommended.
Okay, just so I need to, yeah.
Yeah, people have. So sorry. Sounds good. I'm gonna leave a remote here. Is that for the power? Yes. You're running it right off this. Okay, well, the keyboard and the clickers should work as well, just in case you want to. Yeah, okay. In fact, if you've got this here, I'm just gonna test it real quick. Yeah. There you go. So yeah, do you want to let her know, obviously she'll know this forward, backward, and measure the laser pointer if she was there too. Oh, I missed a How close do I need to be? My very best. I like you're getting I don't think. Well.
All right, I think we're going to go ahead and get started with our first reaction panel today, which is the title of which is LGBTQ rights and constitutional theory. My name is Marcia McCormick. I'm a professor here at SLU, and I am thrilled to be able to introduce our panelists briefly and moderate. And I'm going to go in the order in which they're going to be speaking. So on my far left is Linda McLean from Boston University. She's the Robert Kent Professor of Law and the co-director of BU's program in reproductive justice. And Professor McLean is known for her work in family law, gender and law, and feminist legal theory. Her most recent book is The Bigot: Learning from Conflicts Over Marriage and Civil Rights Law argues that although denouncing and preventing bigotry is a shared political value with a long history, people disagree over who is a bigot and what makes a belief, action, or attitude bigoted. And in the words of one reviewer, this is required reading for anyone who wants to understand our polarized society and how we got here. Next to her is Craig Conniff. Professor Conniff is the Martha Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia. He writes in health and civil rights as well as on health data regulation and is very active in LGBTQ rights litigation and has filed briefs in the Supreme Court, the 10th Circuit on these issues. His publications have appeared in leading law reviews, including places, like Yale, Stanford, the usual. His docket in practice, while he continues to do litigation work, his docket in practice included a lot of Supreme Court, state Supreme Court litigation, ranging from the contraceptive mandate, the Affordable Care Act, and sexual orientation, change efforts, privacy, etc. And then next to me is Luke Boso, Professor of Law at Southwestern University. He's a prominent voice in national conversations at the intersections of sexuality, gender, class, and discrimination. He too has many publications and leading law reviews, and his scholarship is award-winning. He has twice won the Duke Minier Award, which is an award given to each year's best legal article on sexuality or gender identity. And with that, I'm going to turn it over to the panelists.
Hi, everyone. Can you hear me okay? Oh, there you go. Is this okay? Great. Okay, I'm so honored to be here and be able to comment on Carlos Ball's very rich lecture. One important way in which government acts affirmatively is through anti-discrimination law. And anti-discrimination laws, as our co-panelist Liz Supper could readily tell us, have expanded over time to include more categories. And, recently, sorry, my screen, recently in 303 Creative, the court upheld a First Amendment claim by website designer Lori Smith that Colorado's anti-discrimination law reached too far. And this is a quote from Gorsuch's opinion, which is a mashup of a very important First Amendment case, West Virginia Board of Education versus Barnett from the 1940s, this famous fixed star language, with a case that's actually about regulating access to abortion clinics by putting buffer zones. So the interesting thing I'd like to key in on here is this notion of an uninhibited marketplace of ideas, because what's going on here is that the marketplace for goods and services is being equated to a marketplace for ideas. Now, because I recognize that you may not have had, is it still visible? My screen goes dim every 3 seconds. There it is. Because you may not have had Con Law 2, this is a classic case, and this is an extremely famous passage that's been quoted many, many times in many, many contexts. And so this is the passage that Gorsuch is referencing, and it involved a compulsory flag salute, and Jehovah's Witness children, religion forbade them to do the flag salute. If it were actually the flag salute West Virginia requiring, they would have had their right arm extended in a stiff arm salute, palms up, which made some people very uncomfortable because it seemed very close to a Nazi salute. But the point is, the Supreme Court reversed itself, having 3 years earlier upheld the compulsory flag salute and had this ringing language in Barnett about not upholding the salute. Now, the context of Barnett was nationalism, Nazism. Gobitis upheld the flag salute on the basis of national unity, and that this was an important way to inculcate national unity in school children. But, you know, there was an enormous amount of vigilante and mob violence against Jehovah's Witnesses, and Justice Jackson, as an attorney general, was very aware of this and hated the Gobitis case, according to my colleague Robert Sy. And it was a great opportunity for Jackson to strike down Gobitis, overrule a case just 3 years later. I would argue that Barnett's an anti-totalitarian case, not a libertarian case. It didn't rule out government using persuasion or engaging what I've called, borrowing Michael Sandel's idea, a formative project. What it didn't allow them to do is compel an affirmation of belief by these Jehovah's Witnesses. Now, it is true that Justice Jackson talks about 18th century philosophy of the framers, which really emphasized individualism and had a kind of narrow conception of what government did. But Jackson talks about how the modern state obviously does more, and we accept more economic regulation and so forth. So Barnett has had a very long afterlife. It's been put to many different ends. There's many different passages in this very famous case, including a couple that you see here. The test of freedom substance is the right to differ as to things that touch the heart of the existing order. Another famous one, the very purposes of Bill of Rights is to withdraw certain subjects from the vicissitudes of political controversy. As Carlos is well aware, this case has been invoked across the ideological spectrum, both in favor of LGBTQ equality and against it. And just as an in favor example, in Obergefell versus Hodges in 2015, Justice Kennedy, in explaining why he would not take up the dissent's suggestion that they should wait for more debate, more legislation, more discourse, quotes the vicissitudes of political controversy language. On the other hand, in Masterpiece Cake Shop, in finding that the commissioners acted with hostility toward Jack Phillips because of the way they treated these other three bakers who wouldn't bake an anti-same-sex marriage cake, Kennedy quotes the Barnett passage, the fixed star language, and then says, just as it's a fixed point, blah, 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 so also it's not the role of the state to prescribe what shall be offensive or not offensive. So the case has been used many different ways, including in some public accommodations cases. So 303 Creative, you're probably familiar with it. The point here is just to show how Barnett featured in the case, but basically Laurie Smith, not having previously designed wedding websites, felt God had called her to offer wedding websites to different sex couples to attest to God's story about marriage, but she didn't want to offer them to same-sex couples because that didn't fit God's story about marriage. And she wanted to advertise on her website why she couldn't tell the story of same-sex couples. So Colorado said you can't do that under the anti-discrimination law, and the case ended up in the Supreme Court. So to go back to Justice Gorsuch's quote, the other part of the quote about the uninhibited marketplace of ideas is a Massachusetts case involving a buffer zone. And the Massachusetts lost on the narrowly tailored part of the First Amendment test because Chief Justice Roberts stressed the importance of the sidewalk as a traditional forum for hearing ideas you don't want to hear. So what Justice Gorsuch is doing here is pulling on this case to talk about the point of the First Amendment to preserve an uninhibited marketplace of ideas in which truth will ultimately prevail. So to go back to his, so that's really how Gorsuch is mashing together Barnett and this case. Now, in Barnett, in 303, the petitioner really led with Barnett, right? You can see a lot of examples from the briefs that, you know, this is about the right to speak and be silent, and, you know, the court won't sanction compulsory unification of opinion. I love this one. Not even the Barnett children had to knit the flag. So Lori Smith her conscience is being violated in an even more extreme way than these poor Jehovah's Witness children, who, by the way, were faced with expulsion. And their parents were faced with like being investigated as being bad parents. And they could have ended up being like prosecuted as, juvenile delinquents or something. So just, there's lots of examples of how Barnett is featuring in the pleadings in the case. And here's a First Amendment scholars brief, quoting Barnett, the very Polaris of our free speech thing. You have to go forward and reverse the 10th Circuit or all these terrible things to permit an untrammeled access permit a state untrammeled access within the marketplace of ideas would grant the power to regulate and silence those whose views the state disapproves. And that's Timkovich, the dissenting opinion in Barnett, who, by the way, in 303, cites Barnett 13 times and quotes 9 different passages from Barnett. Okay. And here's Dale Carpenter, Eugene Bullock, Ilya Shapiro. I love this. Quoting Barnett, a society that strives for compulsory unification of opinion achieves only the unanimity of the graveyard. So very serious stakes here. If you let Colorado fine Ms. Smith and make her, serve gay customers, we're talking about like totalitarianism and fascism, and that's what's at stake here. Okay, so I don't have time to give time to the other side, but Liz Supper's here. She was on this brief. They're trying to explain this is not Barnett. This is a distinct situation. You're trivializing what was protected in Barnett, where you apply it to the marketplace of commerce, because when you enter the marketplace of commerce, you lose that complete control that you enjoy in the marketplace of ideas, citing Justice Sandra Day O'Connor in the Roberts versus JC's case. So too, the brief on the merits for respondents tried to distinguish Barnett and Woolley and these other compelled speech cases from the marketplace of goods and services. But nonetheless, Gorsuch follows the dissent in 303, who even quoted Orwell, right? And here we see Gorsuch's opinion. If liberty means anything, it means the right to tell people what they don't want to hear. So this is just one example of Barnett features in Gorsuch's opinion. So Lori Smith's refusal to serve same-sex couples is a form of being silent that we need to protect, just as her advertising her wish to serve only different sex couples is a valuable form of speech in the uninhibited marketplace of ideas. So the marketplace of goods and services has been turned into a marketplace of ideas. And I have about 15 seconds left in 10 slides. I'll try to be quick. Okay, so basically in the 303 opinion, Gorsuch draws on Barnett and other cases that drew on Barnett, like Hurley, to talk about, invading the intellect and spirit, which is the purpose of the First Amendment to reserve from all official control. And basically this idea of whether you find the speech offensive or not, it's protected. Just to give a moment to Justice Sotomayor, if I could. Justice Sotomayor basically says it's really dispiriting to see you invoking Barnett in this case, right? And it trivializes the freedom protected in Barnett. We're not invading Lori Smith's sphere of intellect or violating her constitutional right to digger. We're just asking her, if you're opening your business to the public, please serve all customers. And I'll just close with this thought. Justice Gorsuch stresses the courage of the court in defending First Amendment principles time after time after time, including in Barnett, right? And on the other hand, Justice Sotomayor stresses the courage of the court in standing up to challenges to public accommodations law time after time after time, including constitutional challenges. And you see this quote from Justice Sotomayor in this very powerfully written dissent. And so I'll just conclude with questions about what's next for claims about government compelling orthodoxy and speech, and how does a progressive constitutionalism navigate the use and misuse of Barnett? Thank you. I just need you guys to stop the share, so. Okay.
All right, thank you so much for having me here. I just have to applaud the organizers of the conference, Ryan, Sam, Susie, Julie, for just making this conference so successful. Our host here at SLU, I've been before a few times because I teach in health law, and it's always been a fantastic experience. And Carlos for the extremely generative lecture. In some ways, Carlos's lecture made me think about political theorist Nancy Fraser's 2000 famous 2000 article in the New Left Review, where she talks about the distinction between what she calls the politics of recognition and the politics of resources. She argues that the focus on identity-based movements, which she refers to as the politics of recognition, has obscured the way we think about the politics of resources, and that we need more of an emphasis on the latter that would result in a redistribution of resources from the have-nots to the haves. In some ways, and Carlos's lecture was so generative that it made me think about his work in relation to Fraser's argument, and to think about what exactly a progressive vision of LGBT rights could look like. And in so doing, I actually, in some ways, feel that we need to go further than even his recommendations. And I don't think that if he agrees with me, he would actually object to the overall principle. In what I'm going to say in the next few minutes, I'm first going to try and persuade you that the issue with the movement has not been based on negative versus positive rights, or indeed on the issue of atomistic conceptions of the self versus relational conceptions of the self, but really that we need to think about this in terms of intersectional identities and the redistribution of resources. So first, I'm going to talk about the issue of negative versus positive liberties by sort of marching through the LGBT docket of the court since Justice Kennedy's advent in the court. Before Justice Kennedy, of course, the first gay rights case that the court decided was One Inc. versus Olson in 1959, which concerned the ability of One magazine, which was the first gay magazine, to be mailed through the United States Postal Service, and the Supreme Court held that it could be mailed because the First Amendment protected it. I'm going to concede for a moment for this moment that One Inc. and Lawrence, as Professor Ball argued, concerned negative liberties. But Justice Kennedy's first pro-gay rights case on the court was Romer versus Evans. And Romer concerned the question of Amendment 2 of Colorado, which basically prohibited various localities from enacting laws that protected LGBT, or I think at the time just gay and lesbian individuals in public accommodations. And I want to just read from the way the court characterized Romer. There's note the double negative. Amendment 2 confounds this normal process of judicial review. It is at once too narrow and too broad. This is the famous sentence of Romer. It identifies persons by a single trait and denies them protection across the board. The resulting disqualification of a class of persons from the right to seek specific protections from the law. So what we're seeing here is that there's a denial of individuals to be able to seek protection. The vision here is of a state protecting, and the Supreme Court is intervening to enable the state to intervene to protect. I've stipulated Lawrence, which is the next case in the LGBT firmament of the court, but then we get to Christian Legal Society versus Martinez, which concerned the ability of a Christian student group at Hastings Law School to exclude LGBT students. And the court held that actually California's public accommodation law that prohibit such exclusions did apply. Justice Kennedy's concurrence reads as follows. Students may be shaped as profoundly by their peers as by their teachers. Extracurricular activities such as those in the Hastings program facilitate interaction between students, enabling them to explore new points of view, etc. The law school furthers these objectives by allowing broad diversity in registered student organizations. But these objectives may be better achieved if students can act cooperatively to learn from and teach each other through interactions in social and intellectual contexts. Again, this does not sound to me in the key of an atomistic individualistic approach. And then I want to end with thinking about the court's most recent pro-LGBT rights ruling, Bostock versus Clayton County, again pertaining to Title VII, saying that LGBT individuals are protected by Title VII. And I won't read the quote, but again, it's quite similar to the idea of Romer. The state has certain protections that prevent private actors from harming LGBT individuals, and the Supreme Court is acting to enable the state to extend those protections, to extend those regulations against employers when it comes to LGBT individuals. Then the question of whether marriage is an outlier. Well, Obergefell was preceded by Windsor. And as Amy Howe noted, there was a brief that was filed by a prominent group of libertarian Republicans, including Ken Melman, the former RNC chair, Mary Cheney, and Clint Eastwood, where a group of where they argued, and I should note that one of them was the architect of the argument in the ACA case, that Congress could not use its Commerce Clause powers to enact the individual mandate. And that brief basically argued that Congress did not have the power to define marriage. The idea, again, was this libertarian idea that we should restrict the ability of the federal government to regulate marriage, but also, which was ultimately the direction in which Windsor went. But also, I don't think it was any accident that Windsor was a case that involved estate taxes and the ability of a same-sex couple to prevent estate taxes from being exacted from Edie Windsor. So, and I can talk about how in my vision of Dale and Hurley as well, we're talking about different groups seeking the protection of government, but in different ways, and subsidies from government, which was what the argument in both cases. So to my mind, in some ways, one might think about Lawrence as the outlier in a broader set of cases that involve LGBT individuals seeking to enable and activate the protections of the state. But Lawrence itself, in many ways, and I think as Professor Ball notes and noted, was not just all about the atomistic individual left alone at home, but it involved the ability, the concept of dignity, and the concept of dignity, to my mind, implicates the idea of one standing in society, how one relates to one's fellow individual, and liberty, when spoken about in that context, is a relational concept. It's a signifier of broader social situation and status. So then the question though becomes, and this is arguably my second point, is there internal inconsistency, right? I've talked about cases that still seem that like they could be cases where, like Lawrence, where there is an attempt to prevent government regulation. And I would argue that progressives don't necessarily see the world as separated between negative and positive liberty. In fact, I think many progressives would argue that that distinction is one that is not coherent. Let me just take One Inc. Versus Olson, for example. The case that concerned, one way to think about the case is, can we stop the government from intervening in the sending of magazines by the US Post? The other way to think about it is, can we get access? Can we ask the government to enable us to send magazines by the US Post, right? And so you've got these two alternate descriptions. But I think more broadly, the libertarian the progressive argument is that when one thinks about state intervention, one must think about all of state intervention. And the most awesome form of state intervention is the state's intervention to protect existing distribution of property and goods through the police, through other forms of intervention that maintain these distributions. And if we think about how goods are allocated and the government enacts those allocations, then actually everything falls together, because marriage itself is a way to enable existing allocation of goods. And so if we think about Lawrence versus Texas, for example, Lawrence versus Texas, to paraphrase Justice Kennedy and Obergefell, brought John Lawrence from being an outlaw to being, well, what Bill Estridge would call an in-law, but basically they brought them in within the ambit of state protection. John Lawrence can now sit in his house and be secure in the knowledge that he can call the police if someone breaks into his property. The police will come and the police will protect him, even though under a previous Texas law, he was an outlaw who may have been a little more worried to seek state protection. So what progressive would say is that actually what Lawrence enables is this ability for people with houses, right, and with other resources to with jobs in Bostock and with other resources to seek the protections that the state would provide to people who can afford to buy fancy wedding cakes and who can afford to have houses and other resources. So to my mind, the issue turns less on the question of whether the right is a negative right versus a positive right, or whether it is a conception of an atomistic individual versus a relational individual. Indeed, I think in Fraser's conception, the movements based on recognition are not atomistic. You are being recognized by and interpolated by the government as part of a broader community, which seeks to receive protections. So to my mind, the critique must go deeper, and the critique has to do with the way the LGBT movement conceives of its own community, conceives of the vulnerable in its community. And to just think about this in sort of crass monetary terms, one of the biggest reasons that marriage was pushed, marriage, ironically, which is affirmative regulation, but was pushed by the liberal rather than progressive wing of the LGBT movement, was because it was funded by, and these are the words of a prominent development director in a prominent organization, by white rich men. Right. And they were worried, and before Trump got elected, this was, in my understanding, true, that once the marriage equality was won, that the funding stream dried up to the organizations until actually Trump got elected. And then we see again fundraising based off of that. So one of the ideas, I think, is to reorient the movement into thinking about those who are more vulnerable, who are people of color, who are poor, who are homeless, who don't have jobs, and who are immigrants, thinking about the broader community that can also be LGBT. And I think that requires a broader realignment. And the other is thinking about strategy. So in the article that Professor Ball circulated earlier, which again was absolutely fascinating, in one of his footnotes he talks about Joey Fishkin and Forbath, basically, who talk about progressive vision, and they argue that we should think about legislative interventions. And I think that those legislative interventions are important both at the state and federal level, because now I don't really see the federal government being able to intervene in ways that address many poverty concerns and the like. But we look at states that seek, for example, Medicaid waivers and other innovative programs that allow the kinds of positive interventions that allow a redistribution of resources. So I'll stop there, but I think that overall, what we're looking at is a broader program that doesn't just think about the LGBT community and the axes of oppression as falling simply based upon LGBT identity, but thinks about identity in intersectional terms and oppression in intersectional terms, and that brings the resources of the community and pools them together with other communities to achieve a vision of a more just society. Thank you.
Hello, everyone. Thank you very much for having me. I'm thrilled to be here. It's an honor to be here. The focus of my comments for today are going to be centered around the tension between liberty and equality, and specifically the tension between statutory anti-discrimination laws and civil rights laws that prohibit discrimination on the basis of gender identity and sexual orientation, and then First Amendment claims that seek exemptions to or accommodations from or carve-outs from compliance. So what constitutional theory currently governs this tension? And from a progressive vantage point, what maybe could we imagine to be a better solution in terms of a theory that could govern? When we think about the First Amendment and the Free Speech Clause in particular, these constitutional provisions have historically served as a rallying cry and powerful tools for folks who are disadvantaged and oppressed to associate and organize and advocate freely for their interests. But today, I think popular perceptions about who needs First Amendment protections who are the real victims of governmental overreach are changing. Conservatives and religious groups are increasingly relying on the First Amendment in particular to try to limit legal advances for LGBT equality. And their central argument, we've already heard a bit of, is that compliance with anti-discrimination laws unconstitutionally compels their speech or censors their religious views. And these arguments are having success in federal court. Again, as we've heard a little bit already, just this summer, the Supreme Court in 303 Creative ruled in favor of a religious business owner who didn't want to make a website for same-sex couples. The court held that compliance, or requiring her to comply with the anti-discrimination law that was applicable there, would unconstitutionally compel her to express a message about same-sex marriage with which she disagreed. Take another example, the Sixth Circuit in 2021 issued a case called Merriweather versus Hartop, ruled in favor of a college professor who argued that he had a First Amendment right to misgender his students. The Sixth Circuit agreed, held that compliance with the school's anti-discrimination policy around pronouns and names would unconstitutionally compel him to express a message with which he disagreed. As Professor Ball explained earlier today, the Supreme Court's current rights jurisprudence tends to reflect a libertarian ideology, at least in some important respects. And this ideology is one that restricts the government's ability to regulate and address certain social harms in certain ways. I don't think that the First Amendment has to be interpreted in this anti-regulatory way. I think that there is another possibility, and I think if we're thinking about a different framework and we're thinking about a different structure, we could import existing equal protection principles or theories that rely more on anti-subordination rather than formal equality. An anti-subordination theory of the First Amendment would respond to the inequitable effects of certain speech, and it would not necessarily treat all speech as equally worthy of protection. So I think, in short, if promoting one person's speech or expressive interests over another person's equality interests would perpetuate perception of inferiority about a historically oppressed group, then I think that the First Amendment claim should fail. So let me take a few minutes to kind of provide some contextual guidance on the court's anti-regulatory lurch in these disputes between free speech and LGBT equality. And we've heard about a few of these cases already, but even in some of the court's most celebrated opinions on LGBT equality, Romer, Windsor, Obergefell, this tension between equality and First Amendment liberties has been building. Members of the court have gone out of their way to express concern for religious and conservative speech that might be negatively affected by the pro-LGBTQ outcomes in these cases. Romer versus Evans, this is 1996. The court, as we heard, overturned a Colorado constitutional amendment that prohibited localities from enacting anti-discrimination provisions in the future that would protect on the basis of sexual orientation. So this was a gay rights victory. In his fiery dissent, Justice Scalia characterized those who had supported Amendment 2 as, quote, tolerant Coloradans who just wanted to preserve traditional sexual values. And then, according to Justice Scalia, it was the religious adherents who need protection from, quote, politically powerful gays and other members of the elite class who have insulted and disparaged them by denouncing their anti-LGBT views as, quote, bigotry. And then if you look more recently at 2015's Obergefell, again, a gay rights victory, the court struck down all remaining state same-sex marriage bans, but the majority opinion also stressed that those who object to LGBT equality must still have the room to teach about those beliefs, presumably vis-a-vis expression and speech. One explanation, I think, for why the Supreme Court has grown receptive to the First Amendment as a possible tool to blunt LGBTQ equality is that the court's approach to First Amendment claims in particular is it's especially sort of anti-regulatory in this context. And I'm thinking about a few key rules here. Speaker neutrality rules or content neutrality rules that would prohibit state actors from regulating speech based on what the speaker wants to say, kind of no matter how offensive or hurtful, or who the speaker is, no matter how much power or money that speaker might have to amplify their own voice. Content and speaker neutrality rules, I think initially could be understood as minority friendly because in historic practice, the government almost always sought to silence and punish minority views and disempowered speakers. But today, these rules are often benefiting majoritarian interests in preserving a cultural order more reminiscent of the past. So what would an anti-subordination theory of the First Amendment look like instead? I think in short, focusing on anti-subordination principles would again focus on the effects of a person's expression on another person's equality interests. And we would be focusing here on history, context, immutable characteristics, political power. So in other words, when an individual seeks a right to misgender someone, or to make anti-gay comments in the classroom or at work, or to be exempt from an anti-discrimination law that arguably would compel them to express a message with which they don't agree, I think it should matter if those claims would impose barriers to full participation in civic life for a historically marginalized or disadvantaged group. And the Supreme Court itself has occasionally relied on anti-subordination principles in some of its most famous equal protection clause cases. And I think we can use some of these principles as guides and import them into the First Amendment as well. The famous one, the most famous one here is probably Brown versus Board of Education, 1954. Court struck down race-based segregation in public K-12 schools. And famously, the court anchored its equal protection analysis to the psychological effects that separate schools had on Black school children, focusing on the quote, feelings of inferiority that segregation creates. And then in Obergefell, a more contemporary example, the court was pretty explicit that anti-subordination concerns were at least in play in striking down these same-sex marriage bans, because the majority explained in that case that same-sex marriage bans have, quote, the effect of teaching that gays and lesbians are unequal in important respects and that these laws are demeaning. And then the court went on to state that state-sanctioned disapproval of same-sex relationships, quote, serves to subordinate gays and lesbians as a group. So I think this attention to how the law can perpetuate status hierarchies and perceptions of inferiority can likewise inform First Amendment claims that might lead to more equitable results. And to close, or to get close to closing, I want to draw your attention to one really good tangible example that I like. It's a case out of the Ninth Circuit. It's called Harper versus Poway Unified School District. Factually, this case concerns something that may seem trivial. This is about t-shirts. Here we have a public high school student. He wears a t-shirt to school that says, quote, be ashamed, our school embraced what God has condemned on the front. And then on the back, it said homosexuality is shameful, Romans 1:27. He was asked by the school to remove the shirt. He said no. In response, the school essentially gave him detention and he sued. He brought a First Amendment claim challenging his detention. And this goes all the way to the Ninth Circuit. And the Ninth Circuit essentially says not all verbal assaults are alike, because sometimes certain speech has harsher effects for members of vulnerable groups. And there's a good quote from this case, quote, speech that attacks students who are members of minority groups that have historically been oppressed and made to feel inferior serves to injure and intimidate them, as well as to damage their sense of security and interfere with their opportunity to learn. So the court rejects the First Amendment claim, and it's recognizing in this case that hurtful speech targeted at minority groups, historically disadvantaged groups, historically oppressed groups, that leads to a different kind of inequality that perhaps hurtful speech directed at majority group members may. I think conflicts like these are becoming more and more frequent. They're taking on new dimensions. I think as we saw in 303 Creative, we know which way the Supreme Court is going to go in terms of how it plans to mediate some of these claims. But again, I don't think it has to be this way. I think particularly if we look at state Supreme Courts, lower federal courts, I think that we should feel emboldened to pursue different kinds of litigation strategies in these lower courts to build a body of law that incorporates some ideas of anti-subordination into the First Amendment, revive this, this theory of equality that admittedly is seldom used by the court, but has been persuasive on a few key occasions. Because I really do think that the scope of civil rights laws, and particularly civil rights laws as they relate to LGBT folks in particular, that's part of what's at stake here in terms of how these claims are mediated. So with that, I'll go ahead and turn it over.
All right, so we've just heard from three terrific perspectives, and I want to invite Professor Ball actually to have the first opportunity to respond before we open it up to questions.
Actually, I'm gonna take the prerogative of the Childress Lecturer and make my comments in question forms. I hope that's okay. And I think I'll just ask a question of the ask three questions, one of each of you. And then I'd love to hear your responses. Thank you so much for a really rich and thoughtful set of presentations. Linda, I'm delighted that you're sort of tackling this notion of the role that Barnett plays in the turning of a marketplace of commerce into a marketplace of ideas. And I really like your contention that Barnett really is an anti-totalitarian as opposed to a libertarian ruling. I wonder what the best understanding of the concept of a marketplace of ideas would be that is not libertarian. In a way, not surprising that libertarian justices are using the metaphor of a marketplace to incorporate libertarian ideas by challenging the settled understanding that you refer to that we've had, going back all the way to Katzenbach versus McClung in the 1960s, that once you enter the commercial marketplace, the state asks you not to engage in discriminatory conduct. And so what do you think the best non-libertarian understanding of the marketplace of ideas might be? And Craig, thank you so much for the commentary and I think entirely valid pushing back and raising some really wonderful questions that I want to think about, including issues of intersectionality. And I really like what you've done with Romer and Windsor and presenting a different understanding of Justice Kennedy's jurisprudence than the one that I presented earlier. But I'm wondering how then to understand Kennedy's non-LGBTQ constitutional jurisprudence, right? Can we think about Citizens United and the affirmative action cases and the Second Amendment cases and the agency fee case in ways that are not libertarian, that are ways actually and I guess you kind of hinted at that a little bit about the Boy Scouts and Hurley, and I guess 303 Creative being about the government protecting a different set of minorities. And but I'd be interested in hearing your answer to that, because maybe something odd is going on, right? Maybe Kennedy was really a libertarian on non-LGBTQ issues, but somehow with LGBTQ issues, it became a non-libertarian. I don't know. That's a really interesting point, and I'd love to hear your thoughts about it. Luke, I'm a big fan of your Arizona Law Review article, and I want to engage with it, and I'm going to be adding it to my paper because one of the things I love about that piece is the presenting of the anti-subordination perspective of the First Amendment as an alternative to a libertarian understanding. And I'm wondering what you think, if we are going to incorporate equal protection concepts into the First Amendment, what the proper role of intent should be, right? Because of course, intent under traditional black letter equal protection law is very important, right? The court has made it clear that it's only intentional discrimination that's prohibited by the Equal Protection Clause. Disparate impact is not enough. And one of the striking things I think about conservative jurisprudence on the First Amendment cases that you're talking about, and actually going back to Windsor and Obergefell, is the way in which the conservative justices have deemed people like Ms. Smith to be decent. These are the adjectives that they use in their Windsor and Obergefell dissents, and also in 303 creative, right? These are fair-minded and decent people who hold sincere and reasonable views on marriage. And that seems to be relevant to the granting of somebody like Ms. Smith a First Amendment exemption from the anti-discrimination laws. And I'm wondering if you agree with that kind of incorporation. Though I know that you disagree with their understanding of intent in that particular context. So I'm assuming you do, but just the general notion of incorporating questions of intent into First Amendment. And I promise I will be a lot shorter, whatever else I have to say, because I feel like I've already spoken way too much. So thank you.
Thanks, Carlos. Yeah, so I think that this notion of the marketplace of ideas and the marketplace of commerce, I think it's important to mention, and it's kind of come up in your comments and the panel, in Obergefell or Obergefell, when Kennedy says people with sincere beliefs that marriage is one man, one woman, remain free to teach those views, to advocate those views. Justice Alito warns, and this is another anti-orthodoxy strand, that the majority's opinion by drawing race analogies, well, Roberts as well, race analogies and sex equality analogies, puts traditional believers at risk of being labeled as bigots and treated as such if they leave their homes. So one part of what's going on here is this notion that I should be able to live my faith in every inch of my life, every inch of geography that I occupy. And even though 303 is decided as a free speech case, I think commentators understand that it's her sincere convictions about marriage that are really driving the court's protection, even though they said this isn't limited to religious beliefs. So part of the conflict is trying to sort out who has what rights in civic space, who has what rights, like in Justice Kennedy's Hobby Lobby concurring opinion, right, where they uphold the challenge to the Affordable Care Act contraceptive mandate. Kennedy paints this picture of faith, that it's not just what you do in a synagogue or a mosque or a church, it's every step I take throughout the day. So if you have that model of living my convictions and having it occupy everything I do, obviously if I want to operate my business fully in accord with the dictates of my faith, right? And then if the goal of public accommodation law is full and equal access in the name of that as well as dignity, you have to sort out what's happening. Personally, I've written that I love Elaine photography, which is a New Mexico case in which the concurring opinion by Justice Bassan says, the Huguenots say, look, we're like those Jehovah's Witnesses school children. Why aren't we protected, and the concurring opinion kind of explains that in Barnett, Justice Jackson said that the Jehovah's Witness school children not saluting the flag doesn't have third-party harms. It's not conflicting with the rights of others, but when the business owner refuses to serve customers, there are third-party effects. And then they also talk about Heart of Atlanta, and they say in this respectful way to the Huguenots, this is the price of citizenship. You can live your faith in all these dimensions, but when you come into the marketplace, you have to kind of put some of that aside. Of course, conservatives hated that and said, no, the price of citizenship is way too high. We shouldn't have to put those things at the door. So I don't have an easy answer to this, but I think that Kennedy's language about continuing debate allows people like Justice Thomas to say, in the masterpiece dissent, partial concurrence, people are right to dissent from Obergefell. People are right to question it, and merchants are right to question it and not want to serve, perform wedding-related goods and services for same-sex couples. So this notion that debate, a refusal of service as part of a debate, is part of what we're dealing with. I don't have an easy answer, but I think we have to understand these various strands about orthodoxy when yesterday's majority is no longer the legislative majority in Colorado, then all of a sudden, all these people need to be zealously protected from overweening power of the state, whereas they were happy to use the power of the state through Amendment 2 in the 1990s and argued for the right of the majority to enforce traditional moral views, which the Scalia dissent basically said as well in Romer, right? Yeah.
Thank you for that, Carlos. So I'll say, so first I'll give you what I consider to be a shallow answer and then what I hope is a deeper answer. So the shallow answer is that, as you acknowledge, there are the abortion cases, the affirmative action cases. Yes, when it comes to the government in engaging in affirmative action, it is a libertarian point of view, but there are also private entities engaging in affirmative action. And I think that Justice Kennedy wasn't too happy with that. And so if the government intervenes to stop that, then that's anti-libertarian. We also can see Trump versus Hawaii, right? The government intervention in those cases. And then I think most importantly in criminal cases. So in Maryland versus King, which involved DNA searches, Justice Kennedy sides with the majority, the conservative majority, to affirm the ability for the government to collect DNA and stuff. I have to admit, I was at the time the Deputy Solicitor General of California, and I wrote an amicus brief on behalf of California supporting the position that Justice Kennedy ultimately took. So full disclosure there. But also Carpenter versus United States, which involves warrantless searches of cell phone records. Justice Kennedy sided with Justices Alito, Thomas, and Gorsuch in dissent to say that the government should be able to do that. The Chief Justice, John Roberts, wrote the majority opinion, the liberal wing of the court, to say that actually such searches should not be allowed. So what that makes me think, so I think that Justice Kennedy is just not consistent would be one way to think about it. But the other way to think about it is that I think many progressives would say, except for anarchists, there is no such thing as a thing as libertarian, right? A libertarian is just someone who wants the government to intervene on behalf of the people who have property and on their behalf, and to intervene against those who do not. Right. And so it is then no surprise, and it actually brings into consistency Justice Kennedy's idea that in criminal cases, government intervention is absolutely fine. Right, because there you are intervening in ways that harm the have-nots, right? But then in cases when you talk about people who have resources, we shouldn't intervene in ways that would harm them. And I think that a lot of the LGBT jurisprudence follows in those footsteps, right? So when it comes to maintaining marriage rights, when it comes to intervening on behalf of people with houses, with jobs, who want to go out in the marketplace, right? And who have the money to then behave in the marketplace in the way they want to, Justice Kennedy does want to protect them. Right. And then when it comes to other groups that have fewer resources, he's maybe less forthcoming.
Professor Ball, thank you so much for your questions. I guess I'll start by clarifying what I'm not advocating for. I am not advocating for a wholesale adoption of the court's current approach to equal protection, because the current approach to equal protection does not protect. It is not about affirmative governmental efforts to help those who are most vulnerable and who most need it. If we think about, race-based affirmative action in particular, it's a reflexive application of strict scrutiny anytime the government uses race, regardless of whether the reason is good or bad, reflexive use of intermediate scrutiny for sex, et cetera, which leads to results that make it much more difficult to do beneficial things from the governmental perspective. And then in terms of intent, intent applies in the equal protection context when somebody is trying to challenge a governmental action that isn't facially about one thing, but arguably is about that thing, whether it's race or sex orientation, et cetera. And the problem with the intent doctrine is that the court has defined it very narrowly, sort of looking for almost a malice, evidence of malice, and then is not particularly willing in the context of race and sex discrimination oriented claims to credit any evidence that intent actually played a role in a particular individual's claim. So no, I'm not arguing for that. But what I will say is, in the equal protection context, the times in which the court has relied on anti-subordinating principles, those instances haven't been about intent. The court has focused on effect. Now, in Obergefell, I don't think that necessarily carried the day. I think the fact there was differential treatment on the basis of a certain characteristic, that was the crux of it, and there were some liberty concerns, and the subordinating effect, I think, was just the cherry on top. Brown, it largely did carry the day because that was an earlier iteration of equal protection before the court had kind of refined its intent standards, et cetera. But even if we're not going to incorporate an effect alone standard into the First Amendment, given that we haven't in the equal protection context today. I do think of, evidence of discriminatory intent could be relevant in proving kind of a subordinating effect for a particularly vulnerable group. If we have a more permissive understanding of what that evidence of intent looks like. No, it hasn't been great in the context of race discrimination claims, but where it actually has been great lately is for Christian claimants who are alleging intentional religious discrimination, where the court has been much more willing to find that under the guise of, well, these folks are being oppressed by the government, we need to protect them. Masterpiece Cake Shop was decided almost entirely on a random strand of evidence that one commissioner said something mean about religion, and so therefore there was discriminatory religious intent. And then we get to Fulton versus City of Philadelphia, where the court essentially says going forward in free exercise claims, if the government allows for exceptions to certain policies on an individual basis, that almost creates a presumption of unconstitutionality because of the room for discriminatory intent that creates. So in the religious context, the court is very sensitive to how discriminatory intent can subordinate, at least Christian conservatives. So if we apply that consistently, I would have less of a problem with it in the sort of anti-subordination context for free speech claims.
All right, I think we have time for 1 or 2 questions as well from the audience. So I'll open it up. Oh, all right. It'll take me a minute to get back here.
So I'm just curious about the last line, the creative case, where the quote was told about. And then it looked like what exactly the website they're seeing that people didn't want to hear. Is it something like, no, I won't design a website for you? In which case, could the person have used to be on the type of information? Maybe the website designers don't want to hear, would you build a website for me? I found that horrible, like, about black, but I'm sure about that behavior.
Not very well.
If I understand correctly.
Like this? Oh, that's counterintuitive. Sorry. I had a question about the last line of 303 Creative, just where Gorsuch says the First Amendment protects people who want to say what others don't want to hear. And I'm not, in the context of that case, I've always been puzzled, like, what exactly was it that the 303 creative designers were saying that people didn't want to hear, except, I mean, in the context of commerce, it's just sort of like, no, I won't design a website for you, because they can say whatever they want about same-sex marriage outside the context of like the commercial relationship, I guess is what, but then doesn't it follow too that maybe the people who want a website designed by 303 Creative are also saying something the website designers don't want to hear, which is, would you build a website for me? So I just need help in interpreting that last line of, and the quote from Orwell by Gorsuch.
Well, I recently, on the plane ride out here, I was rereading some of the classic compelled speech cases, like the license plate case from New Hampshire, Woolley versus Maynard, Hurley, the parade case, which was a unanimous opinion, by the way. And I guess the notion of Lori Smith, when you take this notion that freedom to speak also includes the freedom not to speak, and people, have no right not to hear things they don't want to hear, like in the public sidewalk. I guess, like you say, probably what that means is the state of Colorado shouldn't be able to stop Lori Smith from telling potential customers, I can't serve you because it's inconsistent with my vision of marriage as God has called me to share. And then I guess that means that she not only can advertise her intention to discriminate because of her understanding of her calling, but she can also actually have face-to-face refusals of customers if they should approach her. So I guess the message she wants to give is, the only kind of marriage I think is real marriage is what God has ordained. And, you know, in the oral argument, her lawyer said, Lori Smith believes gay marriage is false marriage. It's a false form of marriage. So that's the message I guess people don't want to hear, but she has to be allowed to promulgate, you know? But honestly, I'd love to see some of these wedding sites because as Liz Supper pointed out in her amicus brief, Lori Smith did websites for firms that feature divorce practice. If you really believe in the Christian vision of marriage, wouldn't you believe in permanence? I mean, so I'd like this as, and the oral argument, they were saying, so what if a couple says, I don't want all this God stuff, just give me a website, you know, like I want to see if every website has God's message on it, you know, for, you're always wondering like, what is it exactly? But I think what she does, what she wants to say that they don't want to hear is, I don't want to serve you. I can't serve you because of God's understanding of marriage, basically. So any refusal of service is a message people don't want to hear. And the selective nature of her service is her form of speech as well.
I'll say there was a bit of dispute in the case about which clause was at issue. There was what they refer to as the communications clause in the issue, which I think goes to her being able to refuse service explicitly. And I read it as pertaining to that.
All right, so were you gonna say something, Professor Posa? No.
I was thinking about it, but go ahead.
Well, because I was gonna say we're just about out of time, but I don't want to cut you off if you have something that you want to say.
My only comment about the 303 creative decision is that I do think it leaves a lot of questions unanswered about what in the future will count as expressive conduct, both either affirmative or negative, saying something or not, because the court really heavily relied on this stipulation to that the parties had made below, rather than fully diving into what would count going forward. So I think that's a next stage question to be able to work out.
And can I just say that there's a very interesting draft article by Robert Post, it's posted on SSRN, where he mentions that some of these stipulations were very one-sided in favor of Lori Smith, and it could have been that there'd been a change of personnel and who was defending the case on behalf of Colorado, and that might have been when they were willing to enter into such stipulations that clearly favored Smith's case, right? Because all Gorsuch has to say is, well, this is his stipulations here, right? And so we don't have to answer all these hypotheticals about other cases that may arise down the path.
All right, so I think we are out of time now. So join me in thanking our panelists. What a terrific discussion we had. And I think we have another break for a few minutes, and then we'll move on to our second panel. So there was a component in the moderating meeting that was great.
Yeah, meeting back here.
I'm gonna be a moderator, so you don't know. Like I had a couple of questions.
Yeah. I like.
Yeah. They're all the way up. They're nowhere near the ground. Who's the chair on the put the chair on the way out the dog. That's the one. Wrong direction. That'll be better, right? We could do this too. I saw that Craig did that. I know.
Okay, everyone, I think we're gonna go ahead and get started with panel 2.
Excuse me, folks. We're about to get started with our next panel. So if you want to take your seats, it's about to begin.
Okay, thank you, everyone. My name is Lauren Bartlett. I'm a professor here at St. Louis University School of Law, and I'm happy to move us on to panel 2, the First Amendment, friend or foe of LGBTQ rights. I'm going to go ahead and just do a little introduction of each of our speakers on this panel, but their full bios are available on the Childress website. So I'm going to start with Professor Ho. I'm going to go in order of speakers. Professor Jerry Ho, my friend, has just joined us here at SLU Law this year, and we're so excited to have him. Professor Ho researches and writes in the areas of law and equality, mostly with respect to sexuality, gender, race, and culture. His articles have been published by Yale, Harvard, Georgetown, more. Professor Ho was also the recipient of a Duke Manier Award, the Ezekiel Weber Prize from the Williams Institute at the UCLA School of Law, an award that recognizes the best LGBTQIA+ scholarship published in law reviews each year. You'll see a trend on our speakers on this panel in that regard. Next, we have Professor Anthony Michael Price. He's a professor at Georgia State University School of Law and holds a courtesy appointment with the Department of Political Science at Georgia State. Professor Price's articles in the areas of constitutional law, civil rights, legislation, the law of democracy, and American political development have been published by George Washington, Illinois, Georgia, and the University of Pennsylvania, among others. His book, Constitutional Law and the Force of History, is currently under contract with the University of California Press. And then also just another note on Professor Price. In 2017, he authored the Illinois state law banning gay and transgendered panic defenses in murder trials, the second law of its kind in the United States, which has served as a model for other jurisdictions. Next, we'll have Professor Elizabeth Sepper. Professor Sepper is professor at the University of Texas at Austin. She's written extensively on conscientious refusals to provide reproductive and end-of-life healthcare and on conflicts over religion and insurance coverage. Professor's articles have been published by Yale, Columbia, Virginia, and more. Her article, Doctoring Discrimination in the Same-Sex Marriage Debates, on the issue of religious objections to gay rights, won multiple awards, including the 2014 Duke Manier Award for Best Sexuality Law Scholarship. She also co-authored the book Law, Religion, and Health in the United States. So join me in welcoming our panelists, and Professor Ho, you can go ahead whenever you're ready.
Thank you. Thank you for that lovely introduction. And thank you for having me here. I've been here at SLU for the last several weeks, and it's great to call this place home. And this event definitely adds to that enthusiasm as well. So
I share a theme that I know Professor Ball and other panelists today have mentioned in their respective works, which is that the state of equality and for non-heteronormative sexualities is consistently faced with retrenchment at every point of legal, social, and political progress. My take on this is that it's more complicated than the doctrine alone. There are biases in the law, in the game of equality litigation that both conservative and progressive sides are playing into. All of this can be reflected in the non-application of First Amendment in the two wedding vendor cases that the Supreme Court reviewed after marriage equality and decided unfavorably for same-sex couples. All of this seems to point to the court's creation of a second-class citizenry for LGBTQ identities. And all of it, in my opinion, is wrapped up in the inclusion of LGBTQ identities as part of the sexuality project of the American settler colonial state. This is why preservation through transformation appears in gay rights struggles in the law. The cognitive dissonance gets to us, but we shouldn't be surprised. So the US is a settler colonial state. We differ from decolonized extractive colonial states because the colonizers have never left. They came, took over land that belonged to somebody else, stayed on the land, self-legitimized through the use of their law norms, and have used law norms to deal with the inclusion and exclusion of outsiders, including people who hold out as non-heteronormative identities. According to historians, this part of the settlers' civilizing mission that has kept settlers dominant on the continent. Also, the civilizing or colonizing mission is motivated by identity politics, and the identity promoted by settlers has always been white heteropatriarchy. If you have a dominant settler group that continually reifies white heteropatriarchy, you're going to have civilizing or colonizing projects within race, gender, and sexuality. With sexuality, that project can be traced in part to procreative imperatives placed on sexual conduct during the historical colonial era, and also the marginalization of those who engaged in non-procreative sex acts. Sometimes this was with indigenous people, and other times it was within white settler communities. Later, when identities began forming around sexual conduct and status, this was when the categories of hetero versus homosexual became prevalent, and when the exclusion of non-heteronormative identities really solidified in the settler state. We're still in the settler state because we haven't yet decolonized, ever. The settler state's civilizing mission is still ongoing. This is why settler colonialism is a structure and not a one-off event. It keeps perpetuating. When we talk about structural inequality, that concept takes root in American settler colonial experiences. This is also why true progress is always deferred. If progress is at the hands of the status quo, then it's always going to be on the settler status quo's terms, abiding by settler status quo's norms and values. And this is where critical race theory's interest convergence thesis helps demonstrate how progress is deferred and can explain the second-class citizenry that's being created for LGBTQ identities in the wedding vendor cases post-Obergefell versus Hodges. So let me walk through that. So under CRT or critical race theory's classic paradigm that was espoused by Derek Bell, there are two prongs to his thesis about interest convergence. First, his interest convergence thesis provides that racial progress will occur only if the interests of the minority group converge with the interests of the dominant white status quo. And then secondly, and conversely, under his sacrifice thesis, if racial progress threatens the dominant status quo, then the status quo will not advance the minority racial group, even if there are legitimate remedies to do so. And in fact, the status quo will come up with some seemingly rational excuse for denying progress if threatened. Although this concept resides in CRT classically, I think the interest convergence and sacrifice concepts applies to LGBTQ rights advancements as well. Here, it's the mechanism that animates preservation through transformation, why progress is always deferred in the settler state, and shows how that progress is an illusory stand-in for the decolonization that hasn't yet happened. Historians call this the vanishing endpoint of settler colonialism. Now, to establish interest convergence in the marriage equality cases, same-sex couples had to appear non-threatening to the status quo and its institution of marriage. Same-sex couples were chosen for their sameness or respectability or assimilative features with the heteronormative status quo. So for instance, in Obergefell versus Hodges, the case featured gay litigants who exhibited upper middle class demographics that underscored both a racial and heteronormative conservatism. These litigants were especially chosen, as Cynthia Gozzo has said in her Yale piece, to be quote unquote perfect plaintiffs. The idea was that if they looked the same, they couldn't possibly threaten marriage, but rather they'll fortify marriage, hence interests converging. So then keeping them out of the institution of marriage would then inflict dignitary harms that cast them as second-class citizens. So the settler state authority, i.e. the Supreme Court here, brings same-sex couples into the institution of marriage in Obergefell versus Hodges. Progress occurred because the interests of the minority group converged with the interests of the dominant heteronormative status quo. But in the two wedding vendor cases after Obergefell versus Hodges, we don't have the same script of interest convergence followed. In Masterpiece Cake Shop, where the Supreme Court sided with the Colorado Christian baker when he refused to sell a cake to a same-sex couple to celebrate their wedding, the couple here did not appear similar to the couples in the marriage equality cases. Bless you. This married couple broke all of the assimilationist characteristics that the Obergefell same-sex couple embodied. No seemingly upper middle class conservative attributes here. And as a result, they were likely perceived as, how I term it, as more queer than gay, more non-normative than normative. So even when the Colorado public accommodations law was on the couple's side, the court still rejected their claim. Instead, the court focused on religious hostility that the lower forms had seemingly exhibited against the baker. Beneath the doctrinal moves, the couple, as I argue, lost because their unassimilated queer identities threatened the status quo. And so the court had found a way not to advance the couple's claim, even when the law was on their side, even when there were legitimate remedies to do so, even when public accommodations laws would have protected them, and perhaps the baker's claim wouldn't have survived a First Amendment strict scrutiny test. Borrowing from Derek Bell's racial sacrifice theory from CRT then, I think this is an example of what I call queer sacrifice. Now, in the second wedding vendor case, 303 Creative, we don't even have the opportunity for interest convergence because the case was heard on a pre-enforcement review. The graphics designer here, again in Colorado, for some reason all these cases seem to arise in Colorado, wanted to expand her business to designing websites for weddings that didn't want to serve same-sex couples because of her religious beliefs against same-sex marriages. Well, she sues the state of Colorado under a First Amendment free speech grounds on a pre-enforcement review. She's required them to only show standing, and to do so, she argued that Colorado State's enforcement of its public accommodations laws to make her serve same-sex couples would violate her speech rights with such basis located in her sincere religious beliefs. And as we know, the court sided with her this past summer. What's interesting here is the lack of interest convergence because the strategy was likely not to have a challenge based on any actual same-sex couple being refused service by this web designer. That opportunity was never present, right? So instead, Justice Gorsuch was able to side more easily with the website's designer's credible threat argument, and from there curiously ditch the First Amendment scrutiny analysis. Without interests converging, what we have here is sacrifice again. If progress threatens the dominant status quo, then the status quo will not advance the minority group, even when there are legitimate remedies to do so. And in fact, the status quo will come up with a seemingly rational excuse to deny progress if threatened. So again, 303 Creative, like Masterpiece, fits this queer sacrifice category. First, it's lacking in interest convergence. And when that's missing, what's left is, in this case, is the designer's credible threat argument. that state enforcement of public accommodations law will violate her free speech rights based on her religious beliefs. The court, as reflexive of the status quo and the settler state, didn't advance the protection of sexual orientation in the face of Colorado's public accommodations laws, and perhaps a likelihood that the law would have been found constitutional under First Amendment in the web designer's context. Instead, the court emphasized the uniqueness of her speech in the context of religion in order to side with the designer. In the prior slide that I had with her and the sort of rhetoric about free speech for everyone, you can actually see Professor Ball's diagnosis of libertarianism in there, in the way the campaign sort of had it, where she's talking about free speech for everyone. State interference is a threat to her. Free speech for everyone seems to be atomistic in the way you can look at it. And she definitely wants to be left alone. So from Professor Ball's paper, you can pull out the three elements that he was looking at in the way that we have thought about equality and rights advancements. But in both Obergefell cases, post-Obergefell cases, we see protections evading same-sex couples in cases that should have been more formally examined under the court's First Amendment doctrinal scaffolding. So true progress is still deferred. The settler state has included same-sex couples in its marriage schemes. Assimilation provides the contingent access to that fortification, but same-sex couples and by extension, non-heteronormative sexualities are being placed within some boundary while existing within the settler mainstream. In Masterpiece and 303 Creative, this signals to me their designations as second-class citizens. The First Amendment is neither friend nor foe. It has instrumentality and will be used by the status quo for its own bidding. Queer identities can benefit thusly, but it also likely means that any benefit from the First Amendment protections here would probably come at a price, some interest convergence that perpetuates ultimately the settler state. Thank you.
So first of all, I want to thank everybody at SLU for being just such wonderful hosts, and to the Law Journal for just being excellent all around. It's been really great to be here and see some really familiar faces and be in dialogue with Professor Ball's work. So what I want to talk about today a little bit is about this concept, or a concept called constitutional and political time. And it's this idea that there is a cyclical nature to American politics and to the way in which American politics development, and in turn, the way in which our Constitution and constitutional doctrine develops. We often talk about the Constitution as a singular document that's had a kind of one long-standing place in American political history, as if there haven't been multiple constitutional orders. But in fact, I would argue, and other political scientists would argue, that we've had many constitutions. We've had no fewer, in fact, than 5 constitutions, 5 constitutional orders, which have been distinct in the way in which they have governed, or they have controlled the way in which the American public thinks about rights, thinks about the power of the government, that thinks about the way in which we should interact with one another under our laws. These often come about because of national betrayals, moments in time in which pre-existing dominant coalitions can no longer address the issues that plague American society. So oftentimes these constitutional orders, these 5 different ones, have come about from major ground-shifting elections that completely reorder how we think about government. So in generally speaking, the election of 1800, 1828, 1860, 1932, 1980 are really these order-shattering elections where the ideas of what the Constitution means and what American law should look like and the purpose and nature of American government have been challenged and changed. These moments oftentimes have very critical junctures where the character of our Constitution are in great contestation, and they hang in the balance. And these moments in which the constitutional order is changing and the nature of it hangs on the balance creates moments of constitutional panic where and this is especially true, I think, when out groups that have long not had power are on the precipice of gaining in-group status or securing power on the same kinds of level that the previous in-groups often had, right? In-groups who dominated and controlled what the Constitution meant and what American government should look like. There are two moments in our constitutional history where I think we can look to as being or having similar characteristics, where this agitation about the future of the constitutional order stirred anti-civil rights forces that often leaned and continue to lean today into the libertarian ethos. One being Reconstruction and the other the 21st century backlash to LGBTQ rights, which has only, I think, gotten worse in the last few years. So what do these two moments, Reconstruction and the 2000s, have in common? There has been some limited success, important success, but limited success in terms of ridding discrimination based on, or discrimination that has been enforced by state actors, right? So governmental discrimination and also preserving a right to work. So there's two areas in which progress has been made. But where progress seems to stall, or at least create the greatest amount of controversy, are dignitary rights in the public square, where progressive visions of egalitarianism in places of public accommodation and business and the like are pitted against some libertarian values, or at least the libertarian argument that this is a place where government should not regulate. In the 1860s, in the 1870s, the dominant ideology of the day was called free labor. And free labor ideology saw rights in a way that we would probably not recognize today, and had three distinct silos of rights. There were political rights, there were civil rights, and then there were social rights. These are all rights or kinds of rights today that most of us would just call civil rights, but they saw them in this period as being distinct kinds of rights. Political rights being the right to serve on a jury, the right to vote, the right to hold elective office. Civil rights were about the right to property and the right to contract. Social rights, I think, really were the kind of category of rights that we talk about as being civil rights today, which would be the kinds of rights that we would protect in places of public accommodation and housing in particular. In the late 1860s and early 1870s, there was some resistance to advancing public accommodations laws in Reconstruction states. There were two very big failed attempts to enforce or to create public accommodations laws in 1868 in Louisiana and in Florida, and there was another major failed effort in Alabama. Many of these arguments against the legislation in these states and against the legislation that was proposed in other states was libertarian in nature. We should just live and let live. This idea that in fact, the governor of Louisiana, in fact, said something to the effect of this at the time, that racial prejudices are wrong and they're unnatural and they're not correct and they're immoral, but the natural progress of time will erode and erase racial animosity in society, and government should not intervene. There's arguments that property rights should prevail over the anti-discrimination norms that were being advanced by the progressive radical Republican wing of the Republican Party. There was an argument that capitalism should do the work here. If you have a train ticket because you can earn, or you earned enough to buy that train ticket, that'll prevail and your money will be the thing that does the talking, not an assertion of a right. There's arguments that government can never make people equal, that legislation could never eradicate discriminatory norms or prejudices, and therefore it was not even a proper place of government at all. And that to attempt to legislate in this area was simply to treat certain groups as being special, which is certainly something that has come across in the early gay rights movement, particularly with Amendment 2 in Colorado in the early 1990s. It seemed as if this libertarian ethos that prevented some of the anti-discrimination norms from becoming law would yield to greater Black political power in the South, particularly in the 1870s when some of these laws were successfully put on the books. But there was a great moment in American history that changed all of that. South Carolina was the greatest source of Black political power in the 1870s, with a majority Black population and a majority Black General Assembly that really radically changed and legislated in order to achieve egalitarian norms and to secure civil rights as we would know them today, right? Both civil rights, political rights, and these kinds of social rights where people had to be treated equally and with dignity in the public square. This came at a time where Americans became increasingly concerned about socialism. They saw socialism in Europe, particularly in the Paris Commune in 1871, and they were fearful that Black political power, the power of organized labor, and this emphasis on civil rights and governmental control would take over the United States, destroy capitalism, and kind of just destroy the United States as everybody knew it. And as part of that, there was a great souring on Reconstruction and the concept of civil rights. And the libertarian ethos was revived as a way to constitutionalize norms that would stand for socialism. And these ideas were articulated in Supreme Court decisions. So there was the civil rights cases in 1883 where the Supreme Court essentially said people, and by people they meant Black Americans, should stop asking for special legislation to make them equal. You just can't do that anymore. Or Plessy versus Ferguson, where the Supreme Court essentially said that no matter what legislation gets passed, if you feel inferior, it's your own fault, and you can't do anything, government can't do anything to make you equal in the eyes of other citizens. But at the same time, that all of that negative, terrible anti-civil rights backlash was occurring, the Supreme Court and legislatures across the country were very happy and in fact eager to protect the right to work and to keep anti-discrimination norms protected there, both in the Slaughterhouse case and in Yick Wo. We see, I think, very similar parallels developing in, as an outgrowth of the Reagan Revolution and movement conservatism of the 1980s, and some of the the way in which LGBTQ rights have developed at the Supreme Court and throughout the United States, and the way in which some of the resistance to LGBTQ rights have manifested. Of course, as Professor Ball said, Lawrence and the Obergefell certainly have anti-status norms embedded in them and embraced in a kind of libertarian worldview in order to get to the point where the Supreme Court would say that that kind of discrimination was impermissible under the Constitution, both in terms of criminalizing same-sex relationships and marriage recognition. But we see that the kind of libertarian arguments that were proffered and put forward in the 1800s have come back in the form of the First Amendment: free speech, free expression, free association, and parental rights. The idea of live and let live has been revived. The idea that the marketplace and capitalism should just work all of this out has been revived. And we see it in cases like 303 Creative, Masterpiece Cake Shop, Arlene Flowers, and the like. At the same time, we see a kind of libertarian strain emerge in these Don't Say Gay bills, the idea that parental rights should control over the ability of the state to educate fairly on issues of sexual orientation and gender identity. And at the same time, there is still an eagerness, or at least from the Supreme Court, a willingness to, notwithstanding its efforts to peel back some of the civil rights advancements that have been made for LGBTQ people in the public square, still a willingness, as expressed through Bostock versus Clayton County, to protect the ability of people to work. And so in many ways, I think that there's a striking parallel, right, again, between the development of rights and the pushback against rights during Reconstruction, which embraced to some limited degree an anti-state action discrimination norm, while rejecting or at least embracing a libertarian ethos when it comes to the public square. And the same thing happening, at least now, where individuals in the United States have been pushing back against limited success against state-based or state-enforced discrimination, and the success that the LGBTQ communities had there, and really replacing it with this kind of free First Amendment Lochnerism that has undermined the robustness of the rights of LGBTQ people in public spaces.
Thank you all. I just want to echo all the thanks to the hospitality that we've received here. And I hope to have lots more conversations. I'm going to talk about a First Amendment right that hasn't yet been talked about, which is the freedom of association. Association is the white whale of libertarians, for at least two reasons. One, if you think about desegregation, the real harm there is that you have to associate with people you do not want to be associated with. It is also valuable because of protections for here existing in the rare case in Missouri, right? You can only be fired for cause, right? There's no right to work in this state, unlike most others. That's an infringement on associational rights from the view of the libertarian perspective, that employers have to associate with employees who they would rather not associate with. So I'm going to argue, and we're close to Halloween, so I suppose my theme is this is a spooky story of a doctrine that we thought was dead, and it's come back. So in 2000, the Supreme Court decided Boy Scouts of America v. Dale, a case that, like 303 Creative, pitted First Amendment interests against equality under the law and again under a public accommodations law. And there the Boy Scouts had argued that they need not comply with public accommodations law where their leaders were concerned. And they argued convincingly to the majority of the Supreme Court that the mere presence of a gay man necessarily communicated so as to interfere with the Scouts' ability to communicate an anti-gay message. And a majority of the court, 5-4, sided with the Boy Scouts. Now, its analysis dramatically upended freedom of association. First, the definition of expressive association seemed to really dramatically broaden. An organization's claim of expression, Boy Scouts hadn't really engaged in anti-gay communication. It wasn't a central part of the Boy Scouts mission. In fact, it looked like to some great degree, that perspective had been prepared for litigation. Think 303 Creative, think Hobby Lobby, think about the current manufacture of controversies we're seeing now. Second, the court seemed to defer to organizations on the question of whether an anti-discrimination law significantly burdened their expression. So this effectively means the plaintiffs have no burden. They can simply say, we're expressive, we're significantly burdened by this law, and they're done. Finally, the court muddied the level of scrutiny. The opinion can be read like 303 Creative to demand a presumptive out. You show expressive association and infringement. You cannot face application of anti-discrimination law, to require strict scrutiny of any such law, or to demand some sort of balancing between associational interests and governmental goals. So at the time period, fears surfaced that the right of expressive association, as Justice Souter said, would be an easy trump of any anti-discrimination law and perhaps other regulations of conduct. In dissent, Justice Stevens raised concerns that the right of free speech effectively becomes a limitless right to exclude for every organization, whether or not it engages in any expressive activities. But this dystopia did not manifest. There were lots of claims filed from organizations ranging from beverage distributors to Walmart arguing for expressive association, with very rare exceptions really confined to the facts of Boy Scouts. Even the Boy Scouts didn't often win. The courts rejected each and every one of these claims. So it seemed that freedom of expressive association would not override equality under the law until about 2018, 2019. So probably, I would say approximately since 2015, we've seen lots and lots of claims now again filed that anti-discrimination laws in particular violate expressive association. And they are winning. And this has gone unremarked by scholars. It has gone unremarked by advocates, and 303 Creative is going to add fuel to the fire for expressive association, which maybe I'll get to explain. But I want to give you a couple of examples. So there's a pair of cases from the Second Circuit. And yes, I said the Second Circuit. Second Circuit isn't so liberal anymore, contrary to sort of its carry-on belief. But one thing to note about these cases I'm about to describe is the decisions have been issued from judges who have been appointed by Trump, by Bush, by Obama. We often in a sanitized way say that the Overton window has moved, that the sort of parameters of what is appropriate ways to think about the world have shifted. I think a more appropriate way to think about what's been going on in this area is that our brains have been cooked. There's something that's melted, maybe sticking with my Halloween theme. So in the Second Circuit where, well, brains have been melted, in 2020, the Second Circuit faced a foster and adoption agency that argued that they could not place children for foster or adoption with unmarried or same-sex couples. They made a variety of claims: religion, speech, and expressive association. And the Second Circuit allowed them to proceed on the expressive association claim. So broadening really far from Dale. Why far from Dale? Well, because the Boy Scouts is a membership organization. It's not a social service provider offering children that are in the custody of the state. And they're interacting with outsiders. So we're not talking about insiders, we're talking about outsiders. And so the notion is by simply engaging in interactions with families in order to place children with them, that your ability to express has been violated by the terms of your connections to these people. And then in 2023, the Second Circuit picked up a line that had been planted, I think quite clearly, in the earlier case that read, compelled hiring, like compelled membership, may be a way in which a government mandate can affect a group's ability to advocate its public or private viewpoints. So here it involved a nonprofit, a crisis pregnancy center, that did not want to comply with New York's new anti-discrimination law that prohibits discrimination against people for their reproductive health care decisions. And there the Second Circuit held that this anti-discrimination law violated expressive association of an employer. So an expansion of Dale well beyond the bounds of leadership of a membership organization to a commercial employment relationship. We've seen similar claims in a variety of district courts that have actually been rejected, but are on appeal. And I suspect that 303 will give them some room. There's also a public accommodations case, which is on appeal to the Second Circuit, involving expressive association that could well be reversed there on appeal as well. There's a Ninth Circuit case that extends Dale into the for-profit commercial context. It's a bit of a strange case involving Miss USA, but the long and short is that it does accept the idea that the mere presence of a trans person communicates too much, right? That if you, that it forces people by virtue of associating with them to express a message. Out of the Northern District of Texas, famous Judge Reed O'Connor greatly enjoys issuing nationwide injunctions. This does not involve a nationwide injunction, but it does involve a for-profit employer who has prevailed on an expressive association claim that they need not hire ever any LGBTQ people or anyone who won't comply with their highly gendered dress code. So women in skirts, men in pants, no painted nails for men, et cetera, et cetera. Now, why are we seeing these claims? I think we're seeing these claims because of developments elsewhere in the First Amendment. We often like to silo in classes and discussion across constitutional law, free speech, from free expression, from freedom of religion and beyond. I think these cases are a product, and this is one way our brain is melted. People now talk about religious businesses If you are a for-profit business, you are not religious, period. I think it's important to resist some of what has become received wisdom, thanks to the US Supreme Court, and a social movement that insists that the profit motive is not only consistent with religion, but that religion justifies infringement on the rights of employees and customers and the like. So developments from religion, I think, have pushed in this direction. I think that 303 Creative is going to lend a lot of room to grow for expressive association. So why is that? Well, I think one really concerning strand in 303 Creative is how Justice Gorsuch describes anti-discrimination law, because he describes anti-discrimination law as forcing expression. So for Justice Gorsuch, and this goes to Professor McLean's presentation, for Justice Gorsuch, complying with anti-discrimination law, serving people equally, hiring people equally, it is the government targeting unpopular viewpoints. It is the forcing of parroting of messages of the government. Whereas what we really thought it was is when you serve people equally, you communicate nothing. You don't endorse them. You aren't associated with them. No one thinks that when you sell a cake to a couple, that you are blessing their marriage, that it's a message from you of support. No one reads a wedding, and this is part of keeping in mind the truth. Don't be gaslit by the Supreme Court, right? No one goes to a wedding website and thinks, well, this is clearly an invitation straight from the website designer. They sure do love this couple. Look at all these cute pictures they put there. This is not how we experience the world, and we should not let judicial bodies try to convince us otherwise. So I'll just say, right, the view of anti-discrimination law as forcing expression means that any association who disagrees with anti-discrimination laws is going to be forced to change its message. And if all someone has to say is, I'm expressive, and a court defers and then says this law significantly burdens my expression, which is discriminatory, then I think we are in a universe where employers and public accommodations, housing providers will be able to make claims of expressive association and constitutionalize discrimination. So I'm in the faux camp, I suppose, right now. So thank you all.
Okay, so we're gonna switch things around from the last panel and allow audience questions first. So start thinking about your questions and I'll bring the microphone around. And in the meantime, while I do that, I wanted to ask you all to maybe if you want to comment, how can we move towards the positive rights framework that Professor Ball discussed in this context? What are some practical steps we can take? Maybe you have some comments on that and I'll get the microphone.
So I'll just jump in right away on this one. At the break earlier, I think I was talking to a colleague of mine about this, and I think the first start is to change the mindset of thinking about positive rights as something that might be anti-American or un-American because of the fact that we love the pursuit of happiness and the idea of that. And what that means is that it could have a varied classification of things that we are able to do, hence negative rights, right? So that's something that we've been akin to thinking about our concept of liberty. And to look at positive rights may make us think about Europe. And we don't want to seem European for some reason. And it's un-American. And perhaps the mindset needs to start to shift from there before the more injection of positive rights frameworks. So that's sort of my on the cuff, answer right away.
Mine's a little bit more blunt, which is, one, we have to undermine the legitimacy of the United States Supreme Court. The court needs to be packed. It needs to be punished. It needs to be pressured. Democrats, progressives, liberals need to win elections, forge coalitions, and make clear what their expectations are about what the law should look like and pass legislation. And the final thing, I think, which is, at least for lawyers, practitioners, legal academics, we need to stop triangulating and try to come up with liberal originalism and blah, blah. No, just call things out as they are. Liberal originalism is bad. Sorry, this is my personal thought. Liberal originalism is bad. It is, the conservative legal movement is bad for rights. We need to stop giving it, legitimacy, right? And that's part and parcel, I think, to this idea of the Supreme Court and its legitimacy also need to be undermined. But I think all of these things that I'm suggesting are political solutions and political questions of political organization, questions of how are you getting people to the ballot box? Because ultimately the idea, the misapprehension that courts will save us has done liberals so much harm. And we need to stop thinking that the courts will be the end all be all, and that people will magically discover a liberal progressive vision for the Constitution. It requires political work. It requires a lot more than what we're doing right now.
So I'm really happy for this question because I think this would have been the theme of a different direction I was thinking of going. So I think it's important to recognize that our rights across different substantive domains are linked, right? So if you're free to work in a workplace, but not free to then go spend your money where you want to spend it, you're not free. If you are free to spend your money wherever you want, but people can fire you at whim, then you are not free. These things are interconnected as part of subordinating versus free frameworks where we're truly free and equal. In the public accommodation space, I think this means insisting on enforcement. There have been calls to go into defensive crouch to try to keep cases out of the court. There's no keeping cases out of the court. They don't need cases. They're just making up things. So we need enforcement. We've never had enforcement of public accommodations law in any degree. We need enforcement. We need signs. It sounded silly, but y'all means all means something now. We need to expose violations, and we need to insist that what we're wanting, I think, is a negative liberty. We just want to be free. We just want to move around and have leisure and have the ability to spend and go to work and go be with our families. And it's property owners who are insisting on positive rights, on the state coming in and giving them authority over the rest of us.
Thank you all. Okay, audience, it's your turn. Your turn. Who has some questions? And we have another microphone in the back.
Do you feel that this libertarian pushback is really in good faith, or is motivated by more economic factors, the lack of a strong labor movement in the United States? Every time I read about it, it always feels like they're kind of switching the story or doing a different legal theory. It doesn't seem to be a lot of consistency. Thank you.
I think it depends where you look. So I think there's a lot of selective use of libertarian arguments, right? So in the context of freedom of religion, for example, what I view as distinctly anti-libertarian is, for example, the campaigns around getting public school funding, right? So defunding public schools effectively through so-called school choice programs, right? But the claims being made now is that not only does the Establishment Clause not prevent funding of religious schools, rather the Free Exercise Clause now requires funding of religious schools if you offer funding to any other school. This is a welfare claim by religious schools on states, right? It is very much a claim for redistribution. And I think we're seeing tons of that, right? Catholic Charities receives 70% of its budget from taxpayers, right? So we've made a whole system where we're redistributing lots and lots of funds. If we're going to talk about a politics of resources, those resources are getting sent out. They're just not getting sent out to the most marginalized of people, I think.
I think the search for internal consistency from forces on the political right is a fool's errand, because the same people who say we want this, we want sexual orientation, gender identity out of schools because this is a matter of parental choice, are the same people who are saying gender affirming healthcare, which is consistent with standard medical practice of care, is something that we should remove from parents. So there is no consistency, I think. And again, this is probably a preview into my worldview, or it's how I'm predisposed to thinking about it, but it's all about power, right? What can we do to secure our own power and to impose our worldview on other people? And if it's a libertarian argument that works, then we'll use that. And if it's a pro-state intervention argument, then we'll use that.
I would share that same sentiment as Professor Chris, but I'm looking at it from a settler colonial perspective into thinking about I think the libertarian argument is often a way that settler colonial states will self-preserve. And so if you're thinking about the kind of arguments that are being made, it's always skewed back to a white heteropatriarchal worldview. And so in that aspect, I think it is also, in using your words here, a gathering of power, right? An assembly of power here. So that way, the inconsistencies about, well, when we were talking about in the earlier panel, how come that there are libertarian arguments and then there are anti-libertarian arguments that are sort of running around in the same sphere? It makes sense if you're thinking more narrowly about who is actually espousing the libertarian arguments, and when do they feel like, all right, the other side should not have the same kind of rights that we do, so therefore we're going to espouse these policies or these cases, and therefore it seems to us as anti-libertarian. But really, I think there is less of a, we shouldn't look at it as inconsistency. We should look at it more as an overarching strategy from a particular part of the population.
Okay, we have time for one or two more questions from the audience. Takers. Professor Ball, would you like to add some? Oh, wait, one more. Sorry, we have one in the back.
Hi, you guys hear me?
Yeah.
Hi, so thank you all for the great panel discussion. My question has related specifically to like Justice Gorsuch's jurisprudence in general, but Professor Ho, I really appreciate what you had to say about the commentary you're providing on the U.S., the settler colonial state, how there are different types of hegemonies that have to, prioritize and position themselves in power. But relating to Justice Gorsuch specifically, he's kind of repeatedly come out and criticized the U.S. as a settler colonial state of sorts, particularly kind of like if there's descent in Arizona Navajo Nation, particularly where he does sort of thing like where Professor Kreese, you kind of go into a historical perspective on it. He goes into a historical recounting of how the U.S. has, through its institutions, harmed Native American communities specifically. But then he has this First Amendment jurisprudence where he has this very open view of like how there's a freedom of association, free speech, free exercise. You should tolerate basically anything and everything, even if it is offensive to you. So I just want to ask you a very general question. What do you think he's kind of up to here? Because he seems to have this recognition of history in the United States being full of injustices, while at the same time promoting this very open view of, you could say, discriminatory actions in the present day.
Well, so my response about Justice Gorsuch's opinions actually might be consonant with your observations here. If you're thinking about Bostock is an opinion that he wrote, right? He penned that position in the majority position in that case, which then folded through textualism, his version of textualism, sexual orientation within Title VII. And so when that decision came out, there was a lot of rapture about how this is a very good decision for LGBTQ rights. But if you look at the rationale very carefully, and you look at the textualism that he places on because of sex, he's reading a biological version of sex that is exclusive of a constructivist version of gender and identity. And the way that he creates these examples of how sexual orientation discrimination could be triggered in the workplace in that decision is almost the best way I can describe it is almost mathematical in the way that it is a textualist reading. All of it, if you look at it from a higher perspective, seems to, on one hand, create an anti-discrimination perspective for sexual minorities. But on the other hand, if you look at it again from a 10,000-foot view, I argue that in that opinion, he privileges heteronormativity because he's going back to a biological definition of sex, which precludes a lot of things that we know about gender and sexuality today. So that's sort of where I stand on his opinions. I find them to be very specious when they're pro. I'm skeptical, very specious when they're pro LGBTQ, and then I look at 303 and I think it's actually a very poorly written decision. He talks about the uniqueness of her voice, and I always wondered, is it her voice that her own particular voice, or is it the voice that she's projecting through her business? It's kind of blurry. And that goes back to, I think, Professor Flanders's original question in the prior panel about how the dystopian quote, what is it talking about? What is it modifying? What is it going to describe? And again, I think there's something blurry about it. There's a sleight of hand in his opinions. So that's sort of my take on it.
Okay, last chance for audience question. Okay.
So thank you so much to the three of you for pursuing all these fascinating and very relevant themes. And I have a question for each of you. Jerry, thank you for bringing in colonization perspectives into the conversation. I very much appreciate it. I would love to hear from you a little bit about what gets us on the road to decolonization on LGBTQ issues. I would be interested in knowing whether you think that's primarily a political project. Is there a role for the law in that? Is there anything about current constitutional doctrinal law that gets us going in that process of decolonization? I would love to hear your perspectives. Anthony, I find your analogy to the libertarian ethos arguments in the Reconstruction period fascinating. And I think your work sort of powerfully brings that history to life and makes it relevant to our conversations today. And so I very much appreciate it. You spoke quite a bit about the libertarian ethos in the Reconstruction period. I would love to hear a little bit about the anti-libertarian claims during the Reconstruction period and whether we can learn anything about that today. And Liz, you are kind of my go-to person when it comes to the law of public accommodation. And one thing that I have been thinking about, and I would love to hear your perspective about it. You spoke about Boy Scouts, and of course, before that, there was Hurley. And it seems like maybe in hindsight, part of what got us going down this road was the rather broad application of state public accommodation laws to apply to non-traditional commercial settings, like the St. Patrick's Day Parade in Hurley and the Boy Scouts in the Dale case. And I'm wondering, and it's a counterfactual hypothesis, but I'm fairly confident that if 303 Creative had come up to the Supreme Court in 1995, when Hurley was decided, that it would have been decided completely differently, right? Especially so shortly after the USJC's case. And in some ways, in hindsight, it's a shame that it happened in this order, right? That the expansion of the right of association came in the non-commercial context first, as a result of the broad application of public accommodation laws. And then, 25, 30 years later, here we have 303 creative and everything that all the problems that it's going to bring. So thank you to the three of you.
So I'll go first to respond to your question, Professor Ball. So in looking at settler colonial studies, there is no organizing script for decolonization. So that's one. And theorists have come up with different ways of perhaps getting us to a normative place where everybody is about to give up on settler colonialism and move into something more egalitarian. But unfortunately, there isn't any agreement about what that is. And that's probably, if you think about it, very daunting about how entrenched this system of colonialism is in our ether. But there are a couple of things that I've picked up on, and also it has come up as themes today that might get us to thinking about decolonization. One is that I think going back to your point earlier about different people on the liberal end of things, the progressives aren't as good about talking to each other when they have different causes that they're representing. So multilateral coalitions is probably the start of it. And not just in terms of the causes like housing or anti-discrimination in employment and places like that, but also within different racial minority identitarian groups as well. Because at the end of the day, a lot of the different groups are looking for the same thing, but having different types of conversations that are not they should be cross-pollinating. And that is also a reflection of how the status quo segments or silos these different conversations. It's a tactic to really diffuse, right? And so that's probably primarily where I would start.
So I think the Reconstruction South Carolina is fascinating, and because it is the one place where you get a almost unadulterated vision of what constitutionalism in the United States would look like through the eyes of recently freed persons, and the coalition of Black South Carolinians and white Republicans. And it is very much an idea that's advanced in these Reconstruction years that citizenship without a government that values egalitarianism is worth nothing. And so part of the deal is that government has an obligation to get a substantive equal protection obligation. So it is not just the kind of formal equality, but it is providing and ensuring things like a right to health care. There is criminal justice reform that goes on in South Carolina in this period in a way that most people would not imagine. There is an obligation to pay taxes that's put in the Constitution that basically tells the former planter class to go pound sand, and they use very lively language, and it's great. Right to education, right to healthcare. There were all these different things that they vision as being part and parcel to this citizenship right, in addition to the dignity rights that are necessary for being, or the dignitary rights that are owed to people in the public square. And they hinge so many of these things to the guarantee clause, which is interesting, because of course the guarantee clause really has been underdeveloped for a lot of reasons, which we don't have time here now. But essentially, there's this argument that you don't have a Republican form of government if citizenship is not full for everybody, and that includes all of these things, right, including access to public accommodations. And so, there's truly a vision that's put forward, and it's given all that, and given all the taxes that requires, and the regulation that requires, and the redistribution wealth essentially that requires. I think it's no, it's not a shock that people then called it socialism, and alleged that there was, communism and socialism running amok in Columbia, South Carolina. But that's kind of the vision that they were advancing.
So there's so much I could say on this. So I think you don't have to go back to 95. I think if you go back to 2010, you probably don't get the outcome that you get in Masterpiece and 303 Creative. There have been constitutional challenges to public accommodations laws for almost 150 years. Courts have consistently been conservative actors in this area. There are state court decisions where the statute listed all these places that it applied to, and it said saloons. So you had a tavern owner saying, well, I, of course, can discriminate against Black people. And you had state courts saying, well, yep, doesn't say taverns here. And so constant back and forth with the legislature and the courts. I think this was about constitutionalism. I do think that the public accommodations regime has been one of constitutionalism, but constitutionalism through the legislatures, where legislatures are thinking about when they define public accommodations, it's most places. It's places that are not private, that are open non-selectively, invite in the public. It's a broad category, but it's policing some sort of other values around association and also privacy. I think there's always been a narrative of expansion. So Hurley, which involved a parade, and Boy Scouts of America are described as peculiar applications. I think it's a very convincing way to distinguish them from what's going on now, where we're talking about core retail commercial enterprises, arguing for exemption from public accommodation law. But by that same logic, so was the JCs. So I have a piece nobody read on the JCs and the history there in terms of the back and forth. That was a series of litigation that went for almost 2 decades back and forth. And to your argument around positive rights, right? In the late 1970s, in the lower courts, even though the Supreme Court, we now understood, had closed the door to more expansive or maybe realistic views of state action doctrine, the lower courts often found state action in the USJCs. At the time period, I think it was something like 1 in 4 men belonged to the USJCs. It's actually quite shocking that women could dare to want to be equal members in the JCs in lots of places. And I think for most people, those decisions of the Supreme Court around men's clubs were very shocking. But at the time, in terms of state action, you saw lower courts actually thinking about, well, the JCs is basically administering federal money. They're getting all this money. They're serving as gateways to all sorts of civic positions. They're working with the Chamber of Commerce in ways that mean business opportunities come directly out of membership in the JCs. So we're thinking very differently about where the state is than we are today. So I always find it interesting to look back at that period and think about what might have been.
We're out of time, so time to take a break for lunch. We'll be back at 1:45. Thank you so much to our panelists.
Okay. Yeah, I would. Definitely very interested in our array of options. Yep. Yeah. Yep, and then the right. Yeah, I guess the moderator this time. What state? It's no. People are like. That works.
That's why he said, and I'm like, I usually because I didn't. From a space. From space. You know what I'm saying? Mine will be great. I can do it. No, yeah, I guess. And also because
Yes, you got the email too.
Yeah, I mean.
Did you?
No.
Yep, it's right here. Okay, that's. Yeah, that's especially in a city. Yeah. I'm great for this.
But I am not sure.
At the end of the order, the moderators have been. Yep, it's good to take the opportunity while you can. Yep.
That's right. Yeah, it really is.
Yeah, I saw you uploaded another. Yeah, I'll do it. Oh, yeah, right. Yep. Indeed, so we had several. Maybe have the director of the community here, and yeah, that which was cool to get their perspective. But they were gonna focus mostly on like Missouri, like kind of developments we ran around it. But they weren't able to make it, and so Professor Gillespie actually gave a talk speaking on SB5, just like it was a whole breakdown. So I thought like, well, that would be great. Yep, I'll be hanging out then. That's what I was about to ask. Nope. Okay, yeah, I was in my head, I read it's all day. Not quite. Okay, maybe I got it.
Yeah.
I'm excited for this one. It seems like the one that is has really big potential to be very like directly impacted a lot of kind of is a good also location point.
Yeah.
You're right. Like people are gonna get affected by what yeah.
Great. Yeah, what did you decide on this one?
Originally, I forgot about the slides, so maybe we've been doing the with slides first.
That's totally fine. That's easier than.
I guess we can, I think we can put it down. Unless anyone has any.
Okay, wow. Very fancy. Okay, awesome. Thank you so much.
Thanks for all the We got like, maybe down to 3 minutes. Get everybody thinks on like how they think like political that don't feel power like they think that positive and negative, right? So just that
Alrighty, folks, we're fixing to get started pretty soon, so if you could go ahead and take your seats, we're gonna get started in a few minutes here, so just a little bit of notice. Alrighty, I guess we can go ahead and get started now. Well, good afternoon, folks. Welcome back. Just a reminder, my name is Ryan. I'm the Childress Managing Editor. I'm going to be serving as the moderator for this little panel. This last panel that we've got is centered specifically on transgender rights. We wanted to center the discussion of these kind of larger theoretical discussions today with how it's also going to impact particularly insular group that has been the target of perhaps some of the most egregious pressure. And so on the panel with me today, we have our three fantastic guests, starting with directly on my left, Professor Kelly Gillespie is a professor at St. Louis University School of Law in the Center of Health Law Studies. Her scholarship focuses on health law ethics, policy, and research, and she researches and writes on issues related to public health policy, drug use, controlled substances, and discrimination. Her work has been published in law and interdisciplinary journals, including Cato Supreme Court Review, Arizona State Law Review, American Journal of Bioethics, and she's also co-editor and author of several chapters in prescription drug diversion and pain. Next is Professor Susan Hazeldine. She's the associate dean of experiential education at Brooklyn Law School. She is also a professor of law and the founding director of the LGBTQ advocacy clinic at the law school, at Brooklyn Law School. Her scholarship and law practice focuses mainly on family law, gender identity, sexual orientation, and civil rights. Professor Hazeldine and her LGBTQ advocacy clinic students represent low-income LGBTQ plus folks in a variety of legal matters, ranging from like prisoners' rights to family law and immigration. And her work has been published in Harvard Civil Rights Law Review, as well as Cardozo Law Review, UC Davis, and all sorts of others. And finally, we have Professor Kyle Velty, the Associate Dean of Faculty at and the Carolitz Chair of Evidence at the University of Kansas Law School. Her scholarship focuses on mainly the intersection of sexuality, gender, and the law, and her work has appeared in law journals, including the Yale Law and Policy Review, Cardozo Law Review, Connecticut Law Review, and her recent scholarship focuses on the perceived tensions between religious freedom and LGBTQ rights along three axes: law, policy, and theory. She's also worked on several amicus briefs for going before the Supreme Court, including Fulton v. City of Philadelphia, as well as Obergefell v. Hodges, Masterpiece Cake Shop v. Masterpiece Cake Shop v. Civil Rights, Colorado Civil Rights Commission. And so with that, I'm going to go ahead and turn it all over to Professor Gillespie, who has got a presentation for us up here. Yeah, thanks.
All right, thank you so much. Can you all hear me okay? I'm never sure about these mics. Just making sure. All right, well, good afternoon. Hope you enjoyed your lunch. And I am going to talk to you about a very narrow issue, which is the gender affirming care ban in Missouri in particular. We have the Missouri Saving Adolescents from Experimentation Act. Before I get to the content of that act, I feel compelled to say a word about the word experimentation. First of all, what healthcare providers have been providing in the past, at least, to adolescents who are experiencing gender dysphoria is not experimental, right? Some of it may be fairly characterized as innovative, but at this point, it's pretty much accepted medical practice within those specialties. However, for the sake of argument, let's pretend that it was experimentation or research. I think it's important to remind everybody that in fact, we allow research on children. And what I have on the slide here is just the subpart D of the federal common rule of protections for subjects in human research studies that can show you how we break down research protections for children. And included in that is even research that proposes no direct benefit to the child at all, but is likely to yield generalizable knowledge. And the way we protect children in research, which again, gender affirming care is not, is to rely on what we have relied on for years and years and years, which is the many legal remedies available if a practitioner performs care, provides care that is not what a reasonably prudent practitioner would provide. And we rely on informed consent, right? And in the case of children, we often rely on assent as well. All right. Sorry, that really bothers me, and thank you for indulging me, just getting that off my chest. I have a real issue with it's an experimental thing. It's not. Okay, and here's just the map of here's the map of, as of the middle of September from the Human Rights Campaign that shows states in which there have been laws passed that in part or whole ban gender affirming care for minors. Okay, so let's talk about Missouri's law. It became effective August 28th of this year. It codified a new section in the statute 1911720. It bans gender affirming care via both medications and surgeries for trans minors, because they very carefully define the treatments as those that would apply only to trans adolescents. They create an exception for trans adolescents who receive care before August 28th. They at least do that on paper. What we're finding in effect is because of the increased liability and fears around medical licensure, right? They've taken a page from the common playbook to deter healthcare providers from providing what is otherwise standard of care treatments for fear of what some have referred to as penalties of the process, right? It imposes an automatic state professional licensure revocation based on the provision of standard of care treatments for gender affirming care for trans adolescents only. It creates a new basis for civil liability, free from all existing statutory requirements applicable to healthcare professional negligence in all other contexts. It also amends the section of the Missouri statutes dealing with Medicaid to exclude gender affirming care coverage for Medicaid for what I think, and my colleague who's an expert in Medicaid also reads it as for all trans people. It also amends two other statutes to ban the receipt of surgery as gender affirming care for all trans people, whether they are in state prisons or in jails. Okay, so I'm going to focus on the automatic licensure revocation and then on the tort liability provisions. Okay. Okay, so here's the provision about automatic revocation. So this would apply to people who have a medical license. We also have other groups of professionals that have prescriptive authority in Missouri. So people like physician's assistants who are licensed by the medical board, known as the Board of Healing Arts. We also have advanced practice registered nurses who have prescriptive authority. who are licensed by the nursing board, right? Okay. So the performance of the surgeries or administration of certain drugs to trans adolescents shall be considered unprofessional conduct. And any provider shall have their license to practice revoked. Now, this is quite unusual, right? If you look at the Missouri statutes about the basis for discipline, suspension, revocation, or other forms of sanction by those licensure agencies, you will see a long list of criteria that are examples. So it's include but not limited to the following as to what constitutes unprofessional conduct, right? They aren't a list of you did this procedure to this person, with the exception of abortion, and that's a whole other but related, I think, issue. But for the most part, you see like repeated acts of negligence, for example, is what our medical board requires, not just one act of negligence, right? Things like what we consider fraud and abuse sorts of things, kickbacks, bribes, coercing patients not to get a second opinion, the kinds of things you would characteristically think as, oh, that's very unprofessional, right? So this is different because it says, hey, you give this standard of care treatment and you don't have a license. Now I'm curious to see how this shakes out because a license is a property right. And there are myriad due process protections built into the process. And so even before those provisions I mentioned earlier, where, you know, the following shall be the bases, it's very clear the process where the board has to refer it off to the administrative hearing commission, and it goes through a multi-layered process with eligibility for hearings and appeal all along the way. Okay, now the tort liability. It creates a new tort, which is you give the treatment. That's grounds for a cause of action. So essentially it says it's a breach. We also have quite a few differences from healthcare negligence in any other context. So the statute of limitations is completely different. Where we normally have a 2-year statute of limitations and a very, very limited discovery rule in Missouri. Now we have a 15-year statute of limitations, and it's 15 years from the achievement of 21st birthday, so till you're 36 years old, or from the last date of treatment. So if you got treatment as an adolescent up to 23, I think you could still bring a lawsuit 15 years later. Okay, wait, there's more. Venue. Normally venue is in the place where the negligence occurred. In Missouri, if you're bringing an action for this, you can pick any venue you want, any county, right? So if you're a plaintiff and think that the city of St. Louis jury might not go your way, you can pick the most rural, anti-trans county in the state. Okay, what else? It creates a rebuttable presumption if you have infertility. So if you've had gender affirming care, you have infertility. Infertility is not defined, so need not be irreversible. As I'm reading it, that creates a rebuttable presumption that the treatment caused the infertility that can only be overcome by the showing of clear and convincing evidence, right? In a civil tort action, okay? Damages. We have a damages cap in Missouri. It's normally capped at $400,000 for non-economic damages. $700,000 for very serious injuries or death. Oh, no, this law, you get a minimum of aggregate damages of 500,000, but the damages are treble, including treble punitive damages, okay? You don't need an affidavit of merit that the claim has merit ahead of time. And on and on. There are a couple other things, but those are sort of the highlights. Sorry, I had animations and I got all excited and forgot. Okay. But here they are. Okay. Exclusions. One exclusion I'll mention that a student pointed out to me. There's an exclusion for treatment if the person has certain, genetic differences that have been identified, and some other language that, as a student pointed out to me, so if somebody is born with ambiguous genitalia and they have a gender forced on them, they couldn't use this provision. It would have to be under the traditional negligence rules. Okay. So obviously, like in many states, this is being challenged. It's very much in the active phase. I think they are, as of yesterday, they were waiting for the appointment of another judge. It's new change. There have been multiple changes of judges. There was a denial of a temporary injunction earlier in the year, but it's progressing through on several bases, but all based in state constitutional law. And I am over my time, so I'm just going to say thank you.
Great. I think that speaks to the very difficult moment that we're in, and I think that at these moments it's so precious to have a chance to gather like this and share ideas with such an incredible group of colleagues. So I really want to thank the organizers again. Okay, is it working now? Oh, good. Okay.
Yeah.
All right. I want to say thank you for that incredibly sobering account, and wow, these are dark times. And I guess I was just saying that at times like this that are very dark, it's an incredibly precious opportunity to gather with so many incredible colleagues and share some inspiration and ideas. And I want to thank Professor Ball for the timely call to resist efforts to marginalize LGBTQ people without inadvertently reifying libertarian narratives that suggest freedom and equality can be achieved just by getting the government to leave us alone. I definitely couldn't agree more with that perspective. For one thing, I think it's so important to remember that many of the most marginalized and vulnerable trans and gender non-conforming people must exist in spaces that are entirely controlled by the state, right? As Professor Ball points out, schools, but also prisons, hospitals, group homes, homeless shelters. In all these places, of course, there is no way to get the government out because the state's running the show. So one tool that I hope can assist trans people in fighting to be treated fairly in such spaces is a disability justice frame and the Americans with Disabilities Act, or the ADA. I think the ADA is a really important resource in addressing the violent mistreatment of trans people, not just because it applies to many areas of life, including employment, public accommodations, and government programs, but because the definition of discrimination used by the ADA, namely that failure to provide reasonable accommodations constitutes discrimination, I think is particularly appropriate for addressing some of the barriers that many trans people face. So as I'm sure most of you know, the ADA passed in 1990. It was heralded as the world's first comprehensive declaration of equality for people with disabilities. And the ADA defines disability very broadly, right? to include, quote, a physical or mental impairment that substantially limits one or more life activities of an individual. And a person who has such an impairment or a record of such an impairment or is regarded as having such an impairment is protected by the statute. Unfortunately, however, the ADA categorically excluded from the definition of disability, quote, gender identity disorders not resulting from physical impairments, unquote, which it characterized as sexual behavior disorders along with pedophilia and voyeurism. And the legislative history of the act, which has been extensively analyzed by Professor Kevin M. Barry, among others, makes clear that this was the product of anti-trans animus. So senators pushing for these exclusions made explicitly transphobic remarks. There was no hiding the ball here. And so, as Professor Barry puts it, quote, the ADA became in effect a moral code. Disability coverage applies to those we pity, not to those we despise, unquote. But notwithstanding the exclusion of gender identity disorders from ADA coverage, several courts recently have held that trans people suffering from gender dysphoria and facing discrimination on that basis may have a valid ADA claim. Most significantly, in its 2022 decision in Williams versus Kincaid, the Fourth Circuit became the first court of appeals to hold that gender dysphoria is a covered disability under the ADA. And the Supreme Court denied cert on that case this past summer, leaving the Fourth Circuit ruling to stand. So what that means is, at least in Maryland, Virginia, West Virginia, North Carolina, and South Carolina, gender dysphoria is in fact a covered disability under the ADA. So how did the Williams Court reach this conclusion, given the exclusion of gender identity disorders under the law? Well, first, the court noted that the condition that Ms. Williams was suffering from was gender dysphoria. And of course, gender dysphoria didn't even exist as a diagnosis back in 1990 when the ADA was passed. Rather, the Diagnostic and Statistical Manual of Mental Disorders, or the DSM, of the American Psychological Association that was in effect at that time included only gender identity disorder. Gender dysphoria didn't become a diagnosis until the DSM-5 came out in 2013. And second, there are significant differences between gender identity disorder and gender dysphoria. The gender identity disorder diagnosis pathologized gender variance itself. So a person was considered disordered for having a gender identity that didn't accord with the sex they were assigned at birth. The gender identity disorder diagnosis, of course, reflected the now rejected medical view that a mismatch between a person's gender identity and their assigned sex was itself a problem in need of treatment. But a gender dysphoria diagnosis, by contrast, is only appropriate when incongruence between one's gender identity and gender assigned at birth is accompanied by clinically significant distress. So treatment for gender dysphoria is aimed at eliminating the distress, not the identity itself. So since gender dysphoria is not the same as gender identity disorder, the Williams Court ruled that it does not fall under the ADA's exclusion of gender identity disorders, and that therefore gender dysphoria is a covered disability. So of course, it remains to be seen whether other courts of appeal will follow the Fourth Circuit. But I certainly hope they do, because I think the statute has tremendous potential to address the exclusion and mistreatment that many trans people face. And that's because under the ADA, discrimination is not just a matter of treating someone differently on account of their disability. It also includes failures to make reasonable accommodation to allow a person with a disability to work at a business, access a government program, or partake of a public accommodation. So for example, under the ADA, the failure to widen the door or install a ramp so a person in a wheelchair can come in is just as much discrimination as putting a sign up that says no people with disabilities allowed. So the reasonable accommodation conception of discrimination takes policies and actions that appear non-discriminatory and neutral, like having a narrow door, but nevertheless operate to exclude and demean disabled people, and it renders those things impermissible violations of the statute. And I think that conception of discrimination is particularly suited to addressing the systemic mistreatment that transgender people face, particularly some of the most vulnerable and marginalized trans people who, again, are struggling to survive in homeless shelters, prisons, foster homes, and other institutions. Because many times, the policies and rules in those spaces that operate to demean and punish trans people for being trans appear neutral and non-discriminatory. They're not explicitly designed to single out trans people, but they nevertheless operate to oppress and exclude them. And I want to give an example of that. So the students in the LGBT clinic that I teach, and we represent a trans woman who's incarcerated in South Carolina. And she's legally changed her name to reflect her female gender identity. She now has the legal name Sophia, but the Department of Corrections still calls her by her dead name. In fact, her former name appears in large letters on her prison ID card, which she is required to wear attached to her chest every waking hour of the day while she's in the prison. Her dead name also appears on the communication system that she is required to use to email or call her loved ones, so that whenever she reaches out to someone outside the prison, she must send the message as Miguel, even though, again, that is no longer her legal name and obviously does not reflect her true gender identity. And that's because the South Carolina Department of Corrections has a policy that all prisoners are referred to by the legal name they had when they were incarcerated, regardless of whether they changed their name later. Now, as far as I know, that policy wasn't adopted to increase the suffering of trans prisoners. It wasn't directed at trans people particularly, and it applies to all people incarcerated in South Carolina prisons, not only trans people. Similarly, while the Department of Corrections allows trans women in prison to wear the same sports bras that it issues to cis women, padding your bra by putting tissues or socks in it to make your breasts appear larger is not allowed. And in fact, padding your bra in a prison in South Carolina, it's a disciplinary violation. It can result in punishment. It can result in administrative segregation. And again, the policy that prisoners can't pad their bras doesn't appear to target trans inmates particularly, but the effect of forbidding a person from altering their body to reflect their feminine gender identity, not to mention forcing her to wear a badge with her former male name on it and to communicate with loved ones under that name, is profoundly alienating and distressing. Conversely, allowing that person to use her chosen name in prison or pad her bra, it's a reasonable accommodation, right? It reduces the psychological suffering that she's experiencing as a result of her gender dysphoria, and it does not impose any undue burden on the Department of Corrections. So while those forms of discrimination might not violate the Equal Protection Clause because they're facially neutral, they're not adopted to single out trans people, they do violate the ADA, at least in my opinion, because the South Carolina Department of Corrections has failed to grant a reasonable accommodation to alleviate gender dysphoria. Of course, lots of other failures might violate the ADA as well, right? Including failing to grant trans prisoners access to gender-affirming medical care, which South Carolina also does, failing to give people safe, appropriate housing in prison, school policies that don't allow trans students to play on sports teams, or employers who don't allow trans workers to use the bathroom in accordance with their gender identity. All of these instances of discrimination are also arguably ADA violations. More generally, I think the disability justice paradigm, which centers intersectionality and, as poet and activist Naomi Ortiz puts it, quote, values access, self-determination, and an expectation of difference, as well as, quote, being able to be our whole self, all of our identities together, unquote. I think that powerfully reflects the needs of trans and gender non-conforming people to be able to express their true selves rather than conforming to hegemonic gender norms that are so often violently enforced in public life. So I would therefore argue that the ADA and other disability civil rights laws can be a powerful tool to fight for government policies that support and affirm trans people. Thank you.
Hey, can everyone hear me all right? Good. I want to echo the thanks that all the panelists have expressed. We're very grateful to be here and be part of this conversation. Thanks to the organizers, thanks to Carlos for a wonderful paper to really have us think deeply and meaningfully about how do we change what is currently a very dark era in our history. So of course, as we all know, one of Carlos's themes in his paper is really kind of just don't get in the way of progressive, distributive, and egalitarian goals, right? How can we not get in the way of those goals through particular litigation strategies and positions that we take? And I think importantly, Carlos, you take the position that it's not necessarily incumbent on individual attorneys with their individual clients to kind of eschew what works, right? You can go for the, the atomized kind of approach when you're representing a particular client. And rather it's incumbent, I think you would say, for progressive activists and commentators and folks like us to be thinking about different paradigms for moving equality forward. And so while it might not be incumbent on particular attorneys to be attentive to these issues, and I agree with you on that position, I want to focus on a different stage of the life cycle of the civil rights movement, the LGBTQ rights movement, and a different point of the life cycle of an impact litigation case. And I think that this particular part of the life cycle that I'm about to talk about of a big case before the Supreme Court should be attentive to the goals that Carlos has laid out in his paper. So the stage of the life cycle of a lawsuit that I want to talk about is the post-mortem, when after the United States Supreme Court issues an anti-trans, anti-LGBTQ, anti-equality decision, the message of movement lawyering around what those cases mean. And I am going to make a pitch that we need to debunk what I call the narrowness narrative of civil rights organizations. And I'm going to talk about that, and I promise I'll connect it to trans stuff by the end of my 10 or 12 minutes with you. So I'm going to focus on Masterpiece Cake Shop, on Fulton, and on 303 Creative. I'm going to briefly describe what I mean by the narrowness narrative. I'm going to talk about what I think are the harmful consequences of the narrowness narrative, and I'm going to connect it to trans rights issues. You can tell me how I do at the end. So what is the narrowness narrative? It's something that I've observed ever since the Masterpiece Cake Shop case was issued, where national civil rights organizations, LGBTQ civil rights organizations like the Human Rights Campaign, the National Lesbian Gay Task Force, the Human Rights National Center for Lesbian Rights, Lambda Legal, will, upon these issuances of what are, I think, vast overreaches in what the law actually holds and a radical revisioning of civil rights, will come out, and the lead that they lead with is this was a narrow win, right? This was narrow, and actually it was such a narrow opinion that gays actually won, right? This was not a loss, it was actually a win, and it was very, very narrow. And they frame these religious exemption cases as narrow decisions that, again, in some ways they construe as wins for LGBTQ people. Now note, I'm focusing these observations on national LGBTQ rights organizations who are doing this. And I acknowledge it's not individuals like, for example, Liz Sepper, who had, I think, an op-ed in the LA Times, right? Saying, like, ringing the alarm bell, like things are off track. So I'm not focusing on individual commentators or legal academics. I'm really looking at the national orgs who are agenda setters or movement lawyers, movement lawyering for the causes. Because I think the national organizations have a unique and special place in our societal dialogue on rights and equality. So I want to just give a few examples of what I mean by this narrowness narrative. And I will note, I don't want to overstate my case. I'm not arguing that these organizations are making categorical descriptions that everything is hunky-dory and everything's super narrow and we're winning everything, but rather that they're tending to bury the lead, which is there's a radical revisioning of rights happening at the Supreme Court right now. And so, for example, Masterpiece Cake Shop. There's two GLAAD organizations. There's GLAD and then there's GLAAD. So GLAAD, the advocate and defenders, they said this is a limited ruling that provides no basis for the cake shop to refuse goods. The GLAAD with two A's, that they're the Gay and Lesbian Alliance Against Defamation, said this is a narrow ruling in favor of the baker. Lambda Legal says it's a limited fact-specific victory. The ACLU says it's based on concerns unique to the case. NCLR says narrow fact-based decision. We see the same narrative of narrowness from these national organizations after Fulton. GLAAD said it was a narrow Supreme Court ruling, limited ruling, focuses on specific contractual language. The Family Equality Council talked about how the court just focused on particularly facts of the case. It was a narrow ruling and it was a victory. Here's the win kind of vibe. It was a victory for the principle of non-discrimination protections. The ACLU, as to Fulton, says the court issues narrow fact-specific ruling, does not create a license to discriminate. So there's the narrowness, and we're all also winning because we still have the right to be protected by anti-discrimination law. In fact, the ACLU statement went on to say that they were relieved by the court's decision in Fulton. NCLR, Fulton talked about a partial victory. That's how they framed Fulton. They were relieved also by the narrow SCOTUS ruling. The Human Rights Campaign talked about Fulton as not a complete victory, and it does not negate the fact that every qualified family to be a foster parent is valid and worthy. The Freedom for All Americans, after Fulton, issued a statement that said it affirms the value of non-discrimination laws, but narrowly grants case-specific exemptions. So we see this over and over, this narrowness narrative with a little bit of a silver lining in it. We see a little bit of shift after 303 Creative this past summer, although not completely. GLAAD says that it was a highly fact-specific decision that gave a narrow exception based on the unusual nature of the transaction in the case, a transaction that never happened, by the way. GLAAD talked about, did say there was no narrowness in this one, right? So we have a little bit of a break from this narrowness narrative after 303 Creative, but not unanimous. The NCLR said, while the court's holding is narrow and will apply to only a very small number of businesses. Lambda Legal called it misguided but narrow. I think 303 Creative is anything but narrow, anything but narrow. And then Equality Ohio, which is not a national one, but an example of this happening on a more regional or state level. Equality Ohio talked about 303 Creative as giving an exemption to anti-discrimination law based on the facts stipulated. And the court majority created a narrow ruling in Ms. Smith's favor. So I contend that this framing by national organizations that are setting the agenda for queer people around the country hides important and disturbing trends of what the court's actually doing. And what they're actually doing is every time a Christian conservative asks for an exemption, they win at the Supreme Court so far. I think this framing obscures the connections among and between civil rights of other marginalized groups along axes of race, class, sex, reproductive rights. And as per to this panel here, transgender rights. I think the framing minimizes the vulnerability and the risks to all marginalized groups. And I think the framing discourages broader thinking about what will or could be viable in terms of a long-term strategy to stop the onslaught of conservative attacks, not only on queer people and trans people, but on all marginalized communities. So how does all this narrowness narrative that I'm talking about connect to trans rights? I do think it does connect directly to trans rights. But before I get to that connection, I want to give a super brief drive-by of the state of the world for trans people. I could spend my entire time rattling off statistics. I'm not going to do that other than to say it is dire, dire, dire for trans people. They've been the central target of conservatives for the last several years in state legislatures, and they have their sights trained on trans kids in particular, as we've learned about here in Missouri. I will say that in this past year, 496 bills in 48 states were presented that were anti-trans bills. 40 of them passed, 364 were active. They involved things like bans on gender affirming care, like we see in Missouri, anti-trans sports bills, gender affirming care, pronoun use in classrooms, conversion therapy bans, which are good, but they've been challenged in court. And some of those challengers have won, overturning conversion therapy bans based on the First Amendment speech right. And in my home state of Kansas, on July 1st, it became law, something known as the Women's Bill of Rights, which is anything but that, but essentially says for any law in Kansas or any regulation or rule that uses the word sex, that definition across the board is biological sex assigned at birth. In other words, taking away any opportunity for gender identity to be what legal sex is when we're interpreting statutes that classify based on sex. I also want to note before I tie all this together and wrap up, that just the debates themselves in the state houses, they make an impact. There's been studies done by one of my colleagues in social work at KU and others that over half of LGBTQ people who were surveyed say just the debates in the news and in the state house themselves about the possibility of restricting the right to be free from discrimination affected their mental health and made them feel less safe. And 86% of trans and non-binary people had that same reaction. So the debates themselves actually matter in really deeply important ways on the ground every day. So looping back to my narrowness narrative and connecting it to trans rights and to Carlos's larger project, as I noted, I think the narrative is harmful in the ways that it obscures the dynamics of what's really going on. Religious exemption seekers are 3 for 3 at the Supreme Court. It hides the persistent erosion of anti-discrimination law, which may discourage intersectional thinking, narrow our thinking on agenda setting, and in specific cases might reinforce the instinct of attorneys to narrowly frame claims in a kind of atomistic way that Carlos is critiquing. For example, there was this agreement in the parties in Bostock that they would agree that sex, what in Title VII was going to be biological sex. That was very helpful to that case. It was very atomistic in the way that it was framed. But it's also too narrow. It's too narrow to agree that biological sex is how we should define legal sex. That's my opinion, right? I think that legal sex should be defined by gender identity, but we don't have that play in the joints when we agree by stipulation to say that legal sex is biological sex. And so now we're going to see, and we have seen, Bostock being limited to say it's just about being transgender in the workplace. You can come here and not be fired, but you can't use the women's restroom if you're a trans woman, because that's about the conduct. And that takes into account gender identity, which is not what we're talking about. We're talking about sex as biological. And so I think Bostock is limited in that way. And that, you know, they chose that because it was a winning argument. And I understand, right? But now I'm kind of trying to back off and talk about how thinking about the narrowness of these Supreme Court arguments might inform individual litigation decisions. Many trans folks and allies of trans folks will argue, I think in a very persuasive way, that what these laws are doing across the country are really seeking to erase transgender people from the public sphere. That's it. That's the goal. Go away. Don't come out of your homes. The erasure of trans people from public life. And I think that the narrowness narrative makes that claim seem alarmist, seem hysterical, seem unhinged, seem unreasoned. Whereas if we can shift away from the narrowness narrative, it may open space within the movement, within politics, within courts, to really hear that claim about the risk of erasure from society by transgender people, which is both a normative claim and a legal claim. And so I'm almost done. I'm gonna try to wrap up here. I wanna touch on two more things before I close. One is the work of a philosopher named Jill Stauffer, and she writes about something called ethical loneliness. And I think this connects directly with my call, or the call of transgender people, to wake up and realize what the right is trying to do is wipe us away from public life. So Stauffer describes this notion of ethical loneliness as follows. The isolation that one feels when they are a member of a persecuted group and you've been abandoned by humanity or by those who have the power over one's life possibilities, right? That's the state in many ways, who's granting the power over one's life responsibilities. Ethical loneliness, she says, is a condition that's undergone by people who have been unjustly treated by political structures. And it's called ethical loneliness because it's a form of social abandonment that's imposed by multiple ethical lapses, including governments and states. And if we can move to jettison this narrowness narrative, it may make these claims about transgender erasure legible to courts, to politicians, to the public. It may allow us to consider normative and legal arguments for affirmative government interventions to give life to the term of liberty and freedom, and allow the true, authentic flourishing of trans people in public spaces. And then finally, I want to just connect this narrowness narrative to reproductive freedom and to Dobbs. There's a lot of narrowness narrative in the opinion itself in Dobbs overturning Roe, right? Alito basically says, no biggie, we're just sending it back to the states, and ladies, just go vote and all will be well. And Alito minimizes also the concerns about the reach of Dobbs itself, right? He takes on the argument of, are you going to overrule Obergefell next? Are you going to overrule Lawrence next? Because if you're overruling Roe, those are all part and parcel of the same analytical approach, right? And so he minimizes those concerns and says, no, this is narrow. It's just to the reproductive right of abortion. There's nothing to see here for marriage or sodomy, nothing to see here. This echoes, I think, the national LGBTQ rights advocacy organization's postmortems in Masterpiece Cake Shop Fulton, and to a lesser extent in 303 Creative. And this narrowness narrative in queer rights cases may hinder the connections that we might make between the queer rights agenda and Dobbs itself. If you look at the Thomas concurrence in Dobbs, he is chomping at the bit to overturn Lawrence and Obergefell. That line is not hard to draw. And so Dobbs should be understood as the beginning of that unraveling of those rights. It normalizes discrimination every time that there's a win at the Supreme Court for religious exemptions. And normalizing that discrimination, I think, is also part and parcel and a consequence of the narrowness narrative itself. With every religious exemption victory, we normalize the prospect that certain groups can expect discriminatory treatment in the marketplace. One anti-equality project becomes the seed of the next one. And it might be a long road, right, to start thinking about things like ethical loneliness and backing off from the narrowness narrative. But I think it's something that we need to do. I think it distracts from what is needed in this moment, which is constant vigilance and connection making. Today, Carlos closed with, it's going to be a multi-pronged, multi-decade effort. And I think that stepping back from this narrative of narrowness might be one step along that journey. So I'll stop for now.
Thank you guys so much for those contributions. It's really insightful stuff. So we're moving to the Q&A session. And just to give y'all a little bit of time to think of questions, I came up with one. Particularly, I was interested in the panel's perspective on how existing power dynamics, social and political power, how do you see that interplaying with Professor Ball's concept of we should be arguing for positive rights rather than negative rights, particularly with respect to transgender individuals?
I'll chime in real quick. I mean, I think it has everything to do with whether this is a multi-generational project or just a multi-year project, right? How power is being consolidated. Also through connected issues of voter suppression. And this is not my phrase, it's from a law professor that I respect, is, so we can have, we can put babies in boxes, but not ballots, right? That's where we are in terms of the right and access to vote and the franchise and gerrymandering and all of that stuff. So we've got these legislatures in the states that actually don't represent people in the state at all. So I don't think there's a lot of traction right now for this affirmative rights actual claims being made. It doesn't mean we can't be having the conversations in the ways that we've all been talking about today. But I do think back to Amendment 2 in the Romer case, where Justice Scalia was arguing that those non-discrimination provisions in Boulder and Denver that had just been stricken down by Amendment 2, that those were gays asking for special rights, right? There was a special rights narrative, which I think today, if we're thinking about the Christian right asking for exemptions, no one's labeling that as a special rights request or an affirmative rights request. It is not being framed that way, even though I think it can be, and I think it should be, right? They're asking for special rights in a way that the First Amendment has never, ever, ever been construed before. And then I think with trans issues in particular, this is such a salient power and political question, because at the end of the day, transgender identity and also non-binary identity is a really huge challenge to the patriarchy itself, right? Because if we don't have the gender binary, then how do we uphold the patriarchy? How do we know who's a man and who's a woman? Who gets the power, who doesn't? So I think that's why we see so much anxiety around non-binary identities, transgender people, because there's an anxiety about the patriarchy crumbling.
Yes, so if there are any other audience questions, this is the time before we also hand it over. Yep.
So I appreciate so much hearing from a variety of perspectives on trans issues in particular, and especially thoughts about how we can use law that's not necessarily designed specifically like the ADA, that does provide for an affirmative right, for example. I wonder if there are thoughts that panelists might have on using state strategies as well. So there are some positive rights or affirmative rights in state constitutions. I think that I think it's Wyoming or Montana that passed one during the pandemic about access to medical care that's being deployed effectively. Like, so are there places in states that are passing these kinds of things where we might be able to capitalize on those as well?
Thanks for that. I think you make an incredibly important point. And I think given the reality that we confront at the Supreme Court right now, we are in a moment where I think the LGBT movement needs to be looking back to the states and thinking about how we can use state remedies or state legislation or sort of, political power at the state level. I think that's easier in some communities than others. And it's not just about, what does the law say? It's about who interprets it and how easily can it be changed if it comes out to say something that the right doesn't like. So I'm not saying that's an easy strategy, but I think you're right. It's incredibly important. And I think we'll see it, being used more and more, given how hostile the court is right now. I think it's going to be critical.
Yeah, and so I'm just gonna take a little license here where the other thing I think worth mentioning is, although it's not a state law, it's a federal law, section 1557, which is part of the Affordable Care Act and took several existing civil rights laws, including Title IX and Section 504 of the Rehabilitation Act, which, like the ADA, prohibits discrimination solely on the basis of disability, but like the ADA has the same exclusion for the statutory exclusion for gender identity disorder, not resulting from physical impairment. But the Kincaid case and others make me somewhat hopeful, right? That there may be some legs there, and the Health and Human Services put out a proposed regs in September to update amend the regulations for section 504 and embraced the language of the Kincaid case and stated that their thinking is that it would prevent discrimination on the basis of gender dysphoria. So when those, and of course, there's always a religious exemption, but I'm definitely thinking in terms of the Medicaid exclusions and some other things that it might be hopeful.
On the issue of transgender sports, how do you account for the possibility or likelihood that an athlete who is born male and gets through puberty and then goes transgender may have a biological advantage over biological females against whom he may wish to compete?
I'll first of all point out the connection between bans on gender affirming care and the double bind that puts trans athletes in, right? So if we're banning gender affirming care, which would stop puberty and allow that to not allow someone who's assigned sex male at birth, if we can get puberty blockers, that means that person's never going to go through testosterone driven puberty, right? But now we're banning that. And then we're going to say you have to go through testosterone driven puberty. And then we're going to tell you can't play sports. So that's one thing, but setting that aside, I would just say that, especially for K through 12, sports is more about winning. I mean, less about winning and more about growth, development, social connections, learning life skills. And so it's not all about competition and winning. Another thing I would say is that there is a wide variety of biological advantages in cisgender people too, right? Some cisgender girls who are never saying that they're transgender have the same kind of floating testosterone as some men. And we don't tell them that they can't compete in girls' sports. So there's already a natural variety of genetic gifts, and testosterone-driven puberty also is suppressed before you can get on a girls' team. That's another thing. So sometimes there'll be cisgender girls on sports teams and transgender girls, and the transgender girls have less circulating testosterone than the cisgender girls. So I think we need to get away from what I think is a myth that there's always going to be an inherent advantage to performance for people who are transgender girls. It's just not the case. And if we're really worried about fairness, then what we should do is line up all the girls and say, everyone who's 5'10" and above, you're on one basketball team. Everybody who's 5'7" to 5'5", you're on another basketball team. And everything 5'4" and below, you're on another basketball team. Like, if it's really about the fairness of the opportunity for winning, then we need to look at that from a whole nother perspective and start doing it that way. You add it on? No.
Hi there. So like in the past year, the Supreme Court has also overturned affirmative action, which has put a lot of diversity, equity, and inclusion programs into question. Do you think there is like a legal framework going forward to allow for transgendered and LGBT affirmative action or DEI programs, even within private or public spaces? And what would that be?
I mean, I think. Yeah, I mean, it's an interesting question. I guess this goes a little bit back to the temptation that Professor Paul was highlighting for us. I suppose we could say, well, you know, those are not suspect classifications right now, so it's fine. You know, you can still have these programs. You know, I wouldn't advocate for that position, obviously, for a variety of reasons, but yeah, I agree that you know, I think educational institutions, companies have to get creative and have to be thoughtful about how they're going to ensure that they are continuing to create vibrant learning communities that include everyone, or vibrant working communities that include everyone. And I think that, you know, it's going to require people working hard, and I think it's not an excuse to not do it. I think we have to continue to fight for a vision of America that's still inclusive, where everyone is still welcome, where we're not being erased from public life. I think, you know, it's sort of it's on us as educators. It's on, you know, human resources departments. It's all of our responsibility to think about how we can continue to try to make work and school and other opportunities still accessible and available, notwithstanding the incredible pressure that people are under from this onslaught that we're seeing.
Thanks for a great panel. Okay, so Kyle, I wanted to go back to this narrowness narrative. After Masterpiece Cake Shop, Reva Siegel and Doug Nejame wrote an essay insisting that this was not a narrowly reasoned opinion, but it was more positive for LGBTQ equality for a couple reasons. I know you're familiar with this, but just for the rest of the audience. One is that Justice Kennedy rejected the narrative that sexual orientation is special and race discrimination is kind of in a category by itself. And the fact that he cites Piggy Park and other important cases in which anti-discrimination law was upheld against challenges shows that he's rejecting this. And you've written a lot about this, narrowing it so that race is special, sexual orientation, that's just different. He says it's unexceptional that Colorado can protect gay persons just like it protects other persons. So that was one thing. And another was his concern for the impact of exemptions, that you could have a community-wide stigma. So they argued that for a couple of those reasons, this was not narrowly reasoned. Now, of course, in the end, the hostility ruling is, and I think that we can't ignore the change in the composition of the court. You know, I mean, since Masterpiece was decided, we have you know, we've had RBG replaced with Barrett and then Kavanaugh's on the court. And now thankfully we've got Jackson, right? But she replaced Olivia. So I think like when you talk about Fulton, they didn't overrule Smith, probably because they want to protect religion when they want to, you know, as a conservative religion, but they did take that most favored religion. It came to us when Barrett replaced Ginsburg on the court during those COVID cases where the court used to say, you can restrict religious gatherings. It's not, even if you open hardware stores, and there's, well, why are you letting those secular businesses operate and you don't let people sing in a choir? So all of a sudden religion, any exceptions, you said everybody has to have an exception. Religion is an exception. I think we have to reckon with the post-Kennedy court and the post-RBG court and some of the challenges that even if those decisions were partial victories, change the court, you know, it makes it much worse. And Gorsuch may give lip service in 303 to, oh, and it's law.
Yeah, thanks for that, Linda. And I agree with everything that you've said, which is why I tried to distinguish, hopefully successfully, between people like Doug and Riva, who are doing really thoughtful, nuanced analyses and trying to see what do we have left of anti-discrimination law in really important ways, distinguish them and what they're putting into the world with the national works like NCLR, Lambda Legal, which aren't engaging in those nuanced kinds of analyses, right? And so the listening audience, I think, for the national organizations is just much different than the listening audience for legal academics. I think both are necessary and important. And so I was focusing more on that national organization and what harm that I might be doing to a broader agenda or a broader view of what and how we get to where we need to be. But I agree, there's a lot of good stuff in Masterpiece about the underlying principle of anti-discrimination law, and the citation to Piggy Park was especially important, I think.
I just had a quick question about the narrowness narrative. Would you say that the rights organizations would have a tendency to overstate their victories as much as they undersell the losses, or is it more just specifically they kind of undersell the losses more specifically?
Yeah, I think I would say they undersell the losses more. Yeah, I think, yes, I think that's where I'd land on that.
Sticking with the narrowing, you know, I imagine many of those national organizations would say it's to live under a bad circumstance, right? Like there's this bad case, and so we want to say this is very fact specific. And if you have any other fact, it doesn't apply here. And so I'm curious if you have thoughts about sort of balancing that. I think about, I did most of my work in the reproductive rights context. And I think about leading up to Dobbs, which I know you're talking about post cases, but leading up to Dobbs, you know, a lot of the national organizations, including myself, you know, would often say, well, you can't uphold Mississippi's 15-week ban while also upholding Roe. And the court said, oh, you're right. So we'll just overturn Roe. And the sort of other side, when they originally weren't making that argument. So I'm just curious if you have thoughts about sort of balancing that, because I tend to agree that, you know, the underselling of the harm, but I think it is to limit the sort of, you know, case applying other places.
Yeah, I don't disagree with that at all. And I understand the inclination of these national organizations to take these positions. I mean, part of it probably is fundraising based, right? They want to continue saying, listen, there's glass half full here, let's keep on giving, we need to keep fighting these. I think the point I'm trying to make with the narrowness narrative is that I would like the organizations to be attentive to it, right? Know that they're doing it, think about why they're doing it, and think about whether there's a trade-off that's worth it doing what they're doing. Because what I think they're doing is focusing on the trees and not the forest. And part of the things I read out of Carlos is we should stop looking at just the trees and back up and look at the forest. And so I just want them to be thoughtful and intentional about the narratives they're putting out there around these cases. And maybe at the end, when they do the risk analysis and the benefit analysis, they decide to continue doing what they're doing. But I don't know that there's a thought process around it that connects to the kind of ideas that Carlos is trying to get us to think more deeply about.
I think since we're almost out of time, I think I'll just ask one question, and Kelly, if I can ask you the question. I'm really interested in this exception for trans minors who are already receiving the care that you told us about. And I'm wondering if this is, I'm wondering why legislatures are including this, and Missouri, I don't think, is alone in this exception. Sort of what's going on here. Is it an implicit recognition that at least for some trans kids, denying them the healthcare would harm them, and the kids who are already receiving the treatment? Do you think that's what's going on? Or is it maybe kind of a defense of litigation, right? That there may be something problematic, particularly problematic constitutionally from a due process perspective, about denying people, about taking treatment away from people as opposed to limiting the treatment as an initial matter. And I would love to know, and you know much more about this area than I do, but in addition to abortion, can you think of other examples where legislatures have stepped in and said, you know, this medically accepted procedure, we as a legislature are going to decide can no longer continue? So would love to hear your thoughts on that.
Sure. So I'll kind of take that in reverse order. The analogies. So yeah, of course, abortion. The closest thing I can think of, other than bans on conversion therapy, which is not standard of care or innovative, right, is just harm, right, dressed up like medical care, is the one I'm most familiar with in response to the multiple drug overdose crises. Many legislatures and then or medical boards stepped in with either a law or a regulation that starkly limited the amount of pain medication or opioid containing medication that somebody could receive. And those laws were perceived as bans, right? Even though some kind of were over a certain point and some weren't, but they were perceived that way, right? And so you had people immediately cut off their medication who had been on the medication for decades. You had people that were instituted, if they were luckier than that, then they were instituted on super rapid tapers. And many of us sort of raised the alarm at that time. And, you know, it was sort of ignored and like, you don't care about people who are dying from overdoses kind of thing. Like, no, that's not it. And as it turns out, many, many years later, guess what? Right? Suicide rates went way up, right? Overdose deaths are higher than they've ever been, even though our opioid prescribing rates are lower than they've been since the 1990, well before the advent of OxyContin. And, you know, FDA has issued warning, a black box warning. Other big groups have issued warnings to not do this, right? But all of those cases, whether it's gender affirming care bans or abortion bans or, you know, that kind of thing where you ban the kinds of medicine that somebody can take because of some perceived third-party harm. it's just too blunt of an instrument the law is just too blunt of an instrument to use on these very nuanced clinical decisions. And so the people that always end up suffering the most are the people most desperately in need of care, right? Because people who have money and wealth and can move around or fly places, they can get the care they need, right? So it's just another means of oppression. Okay. The reason for the inclusion of the exception, I could be wrong. My perception is that it's not because there's any constitutional issue with that at least in Missouri, it's been construed as like a concession in order to get things passed, but they also must have known, right, that the inclusion of all those other pieces were going to result in an effective ban, right? And that's what we've seen. Many of the groups, many of the big university-based groups have stopped providing the care. And many of the patients have just been abruptly cut off, even ones that have been on therapy for years. And I forgot your other question, but I think that's it. Yeah.
Hi, Kelly. Could I follow up for some of our out-of-town guests? I think part of the answer to your question is why the concession for ongoing treatment. After this bill was first filed this year, there was a lot of publicity around a former employee at Washington University's Gender Transition Clinic. And she made a lot of allegations that children were not allowed to withdraw from care. And then there was a real face to this bill, to this advocacy effort. And I think a lot of that connects with what you talked to us in a workshop yesterday. And a lot of it was parents talking about their children in transition therapy, their fears of them not being able to continue that. So there was a real face to children who would lose this treatment if this bill was passed. So it, I think, was very much part of the local advocacy, part of the conversation, part of a very public conversation with a lot of real people's lives and stories being told.
Alrighty, folks, at this point, we're gonna go ahead and conclude the transgender rights panel just because we're running low on time. But if you could give a big thank you to this fantastic panel. And now for Professor Ball's closing remarks.
So yes, I was asked to briefly end the program, which I'm very happy to do. And I'm going to close by actually sharing with you somewhat of an embarrassing confession. I am the co-editor of a casebook on sexuality, gender identity, and the law. And back in early 2016, my co-editors and I were putting together a new edition of the casebook, and this fleeting, naive, and in hindsight, embarrassing thought entered my head. You got to remember early 2016, Obergefell versus Hodges had been decided the summer before. Don't ask, don't tell. The military service ban Congress had repealed. The Obama administration was issuing regulations prohibiting transgender discrimination in healthcare and in education. And the fleeting thought was, my goodness, I wonder if this is going to be the last edition of the casebook. So much of LGBT equality seems somewhat settled and promising. In hindsight, that was a really dumb thought. You know, obviously, given the ferocious backlash that we've seen over the last few years, involving primarily, though not exclusive, transgender issues, as our last panel so eloquently addressed. And yet, right, as bad as things seem today, and they are, I want to end by saying that as bad as they are today, they are quite a bit better than they were back in the day when I was in law school in the late 1980s. And I know for some of the students in the room, probably the late 1980s seems like a really long time ago. But for some of us, it doesn't seem that long ago. And I find consolation in the fact that as bad as things are today, they are better than they were back in the day when transgender individuals were completely socially and politically invisible. And the fact that we have spent our day together in part talking about transgender equality issues, unfathomable that a conference like this would have been held back in the 80s and even into the 90s. And that really, that's been the trajectory of civil rights in this country, right? It's never been a straight line. It's always been, at least for the last few decades, sort of, 2 steps forwards, 1 step back. And I think that as long as we generally continue with that 2-to-1 ratio, broadly speaking, and we're going through a really rough time now. But again, when we put it in historical context, I think there's reason for optimism. And another reason for optimism, quite frankly, is the symposium that was held here today, right? The fact that we have so many wonderful scholars thinking about these issues, advocating on these issues, also gives me consolation, and I hope it does you as well. It's been a pleasure. I learned a lot today. I hope you did as well. Thank you for joining us. Thank you for having us. And we'll see you soon. Thank you.
Alrighty, folks, that is a wrap on our 2023 Childress event. But if you're a CLE person, your CLE assignment will be emailed out to you on Monday. But other than that, thank you all so much for coming. Thank you to the folks who have made this possible, including Professor Jordan and all the panelists. So thank you very much, and see you later. Okay. Yeah. The challenge in the stack of and there's a lawsuit.
Yes, yes.
Yeah, I'm not quite leaving yet, so I'm just. Fantastic. Yes. Yeah, I just got the book. I'm gonna wait my room, but I'm not gonna go. First, they're not. Yeah, yeah. It's right. Yes, yes. I mean, I just, I was listening to NPR a couple minutes ago, and I heard this author talking about academics, and I was like, that is next to what I'm doing. So like, I call it basically, I was trying to watch the book, so, yeah. Yeah, what's your name? I see your tag. Nice to meet you. Okay. Yeah. Right. Right. Yeah. Exactly. That you feel. Yes. Yeah. I did a search on like the law. And I found 7 law and almost all of them. Yeah, something to put it into the. Yes, right, yeah. So, yeah, I'll send it to you. Yeah. Interpersonal relationships with all I'm going to talk about that was talking about radio last time they're talking about how that can happen in like Black people actually. State, I don't know that we have like structural equality. Yeah. Correct, yeah, so we are, yeah, exactly, yeah, so I'll be able to talk about it after. But, yeah, you can get it on Amazon, yeah, thank you, all right.